Representative for Judgment, CRA 173 of 2001.
In view of the foregoing analysis of the eyewitness testimony, the corroborating medical evidence, the established motive arising from the property dispute, and the proved participation of each of the appellants in the unlawful assembly, this court finds no infirmity in the conclusion reached by the learned trial court. In essence, we are humbly of the opinion that the prosecution has successfully established beyond reasonable doubt that the appellants formed an unlawful assembly with the common object of asserting their claim over the disputed house by force, and in prosecution of that object, set the theft house on fire and inflicted multiple on the vital parts of the deceased, causing fatal injuries. The fatal assault on the deceased Natavara Oja was clearly in furtherance of the common object, thereby attracting the vicarious liability under Section 149 IPC. The conviction of all the appellants under Section 148302 and the conviction of the appellants Yudhishthir Barik and Sriram Barik under Section 436 IPC is thus well supported by the evidence on record and warrants affirmation. It is also placed on record that appellant Basudev Parik has since died and since dead, and the appeal, insofar as it concerns him, stands abated. As regards the remaining appellants, this court finds no ground to interfere with the conviction and sentence imposed by the trial court. As a result, the judgment and order dated 16/8/2001, passed by the learned Second Additional Session Judge Cutter in ST case number 197 of 1999 stands confirmed. The appellants who are presently on bail are directed to surrender before the learned trial court within a period of 3 weeks from the date of this judgment, following which the trial court shall take all necessary steps in accordance with law to secure their custody for serving the sentence. Before parting with the record, this court places on record its sincere appreciation for the valuable assistance rendered by Mr. Nilambar Jena, learned amicus curiae. The court acknowledges his diligent effort and the able assistance for effective disposal of this appeal. This court also records its appreciation for the valuable assistance rendered by Mr. Parthasarathi Naik, learned additional advocate general, whose efforts have likewise been of considerable assistance to this court.
I agree. No, mention tomorrow is special bench. You can mention tomorrow. Huh? Yeah. Mention tomorrow. Tomorrow. This is a special bench only for criminal appeal hearing. The regular bench is tomorrow, so you mention. Yes.
Weekly list, item number 1.
Premature release. So how many appellants are there?
So what happened to the criminal appeal number 40 of 2012, which has been preferred by the appellant number 2? So is it still pending or disposed of? Okay.
Ramchandra Sahu.
So regular appeal, it should have been separately listed. Why it has not been listed separately? This is Ramchandra Sahu.
The
Yes,
other appeal.
preferred. So we can dispose of the jail criminal appeal in the sense because a separate appeal is already there. He has filed appellant number 2. So JCRL there were 2 appellants, out of which one premature release is there. The other man has already filed the regular appeal. So that jail criminal appeal is to be disposed of. And 40/2012 dispose of any tarikh. तार ओरिजिनल फाइल टिके देखो बेले बेले स्कैनिंग गिरन ने कौन सी लगानी जो the counsel in that jail criminal appeal da Prahlad Sahu Panso Mr. Maharaj, it is your case, so it is pending. I think you have to argue the matter.
That's 2 years because after the appellant granted bail, after the appellant granted bail by the some
Yeah. No.
no communication.
No. What is your instruction? He is alive. Alive तो अपन argument करिए और bail जैसे जल्दी result of the appeal so desires will be taken into matters. Have you collected the paper book?
No.
So get the paper book and argue the matter. Judgment है नहीं का? ठीक है. Lekon JCRL number 75 of 2008. This jail criminal appeal has been filed. The jail criminal appeal ta ke jon file करते ले? नसमता तो 2 जन करता. हाँ ठीक है. Has been instituted on the basis of the prisoner's petition received by appellants Nando alias Prashant Kumar Pradhan and Ramachandra Sahu. Stop. It appears that appellant number 1, it appears documents filed by the Land and Council for the state that the appellant number 1, Prashant Kumar Pradhan, has been released prematurely by the government. So far as appellant number 2, Ramachandra Sahu is concerned, since he has filed a separate criminal appeal, that is CRLA number 40 of 2012, which is sub judice, this jail criminal appeal is disposed of. Stop. Criminal appeal 40 of 2012 will account. Mr. P.K. Maharaj, Land Council, appearing for the appellant Ramchandra Sahu, is present, and he submits that he may be given a copy of the paper book. Stop. He further submits that after the appellant has been granted bail by this court, he is not aware about the whereabouts of the said appellant. However, the Land Council for the state has produced the written instruction received from the IIC Daspala police station dated 5/11/2015 that appellant Ramchandra Sahu is alive. The written instruction is taken on record. Let the registry supply paper book to Mr. Maharaj during course of the day, and the matter be listed in the week commencing from 17th of be added to the hearing list on 18th of November 2025. है ना? Yes.
Item 2.
I think you might not Flaxi. Solar plant. Premature release. Solar plant. Solar plant. All right. Reduce the premature release report of the appellant. Which has been এটা কি আপন দিয়েছিল বলে না কি আসলে রিপোর্টটা which is that flaxi মানে এটা কোন আপন দিয়েছিল না কেমতি আসলে রিপোর্ট কেমতি আসলে 2019 ये बोले जो हम और जो मगेଇଥିବେ আচ্ছা সেটা দিয়ে দিই which is at flaxi in view of such report the criminal appeal is disposed of. Yes.
Item 3.
Yeah. He, despite of instruction to the state council in the last occasion, his compliance appeal not to let the opposite party the content will be present in person through VC so that he can apply this and output. Given instruction that the compliance appeal will be filed.
No. Oh, we passed the order on 14/10/2025 and on that day you submitted that instruction sought for on 26/9/25 regarding the status of representation and the matter may be taken up next week. So that is how we listed it in on 23/10/25. On that day also a submission was made that the order has been complied with. But the matter may be
to the state office of the advocate general.
we asked him to produce the compliance
But
report.
despite of that, he did not pick up the phone. Nodal officer today has given him message that he is not all picking it.
Who is that man?
Irrigation that's good.
The same man is there. Ramakant Doli, Ratnakar Doli.
Yes, but they're there because otherwise nodal officer would have intimated.
All right, let's go. He is to ask him to appear day after tomorrow.
Day
Hello?
Day after tomorrow.
Through
Tuesday.
Day after tomorrow is holiday.
As today's Thursday.
Today's Thursday.
Sorry. So let him appear on 11th.
11.
The Learning Council for the state submits that on the basis of instruction received over phone, the Learning Additional Government Advocate made a submission on 23/10/2025 that the order dated 5/11/2024 passed in WPC number such and such has been complied with. And time was sought for to obtain and to produce the compliance report. However, even though in the meantime, several attempts have been made to the nodal officer to obtain the compliance report, but the contender opposite party is not sending the same. In view of such submission made by the Learning Additional Government Advocate, let the Executive Engineer, Jajpur Irrigation Division, Jajpur, the contender opposite party, appear through virtual mode on 11th of November 2025. Pre-copy of the order we handed over the Learning Council for the state. What is your good name, Learning Council? Mr. Saul and counsel appearing for the petitioner is present. Yes. Virtual move time be 10:30.
Item 4.
For a complaint, actually it was filed because earlier the husband was filed a petition before the London civil judge. This is the instruction that was dismissed. CMA.
CMA has also been dismissed.
CMA file.
File that is there.
It's pending.
That you had submitted last time.
reference civil court references references are dismissal of restoration file pending.
So why will keep it pending here? 6 months time he has because once we adjourn this matter 6 months, it would
Let
not
it be disposed of awaiting that same.
so
Awaiting nahi, हमें इटाକୁ dispose of
कर दउछु
एठी जहाँ सेटा भी
so time दी दउछु जहाँ से short for करचंदी do the needful 6 months time मागिचंदी because of this problem.
at his best the matter was initiated.
No, the Land Council for the state has produced the written instruction dated 28/10/2025 of Special LA and RRO, Lawyer Indra Irrigation Project, Haryana, which reads as follows. Put kar do that to so and so. On 28/10/2025, the Land Council for the state took time to obtain instruction regarding the compliance of the order dated 13/1/2025 passed by this court in WPC number 459 of 2025. In view of the aforesaid written instruction received, the content petition is disposed of and you have received the copy.
Yes.
Acha. The copy of the written instruction has been served on Mr. Behra, Land Counsel for the petitioner, who seeks some time to obtain instruction put up this matter on 11th of November 25th. This is taken on record.
Item 5.
Yes, fine.
So the petition they like footage is function. 28 petition is footage with form, but in the notice get signed. So that's why the unstructured the case is pending. So
Entity ଆପଣ କୋଉଠି କାଠୁ ସିଗ୍ନେଚର ନେଇଥିବେ କୋଉଠି ଫର୍ମ ସିଗ୍ନେଚର ଫର୍ମଟା କଣ ଆମର ନଉନାହାନ୍ତି କୋଉଠି LTI ନଉଥିବେ ଯୋଉ
ସେମାନେ 28% ଯୋଉ ଫାଇଲ କରିଛନ୍ତି ଲାଷ୍ଟ ପେଜରେ ଫର୍ମ ରିପ୍ଲେସମେଣ୍ଟ ଦେଇଛନ୍ତି.
No, we are concerned with whether the person is right or not. ଆପଣ କୋଉ ଜାଗାରେ thumb impression ତାଙ୍କୁ କହିଥିବେ ଯଦି ଦବା ପାଇଁ ସିଏ ଠିକ ଅଛି ତାଙ୍କୁ କିଏ ହୁଏତ କହିଥିବ thumb impression ଦବାକୁ. Are you doubting that he is that man?
Notice is signed, that's why they some more time they verify all these things and then thereafter.
ଏଠି ଯୋଉ ଇଏଟା ଫାଇଲ କଲେ କଣ କଲେ ଏଠି ଯୋଉ କଣ୍ଟେଣ୍ଟ ପିଟିସନ ରେ କୈଳାସ ଦାସର ଓକାଲତ ନାମାରେ କଣ ଅଛି? This content petition
Hirosindhu Kata.
Sorry, Hirosindhu Kata. Hirosindhu Kata रे एठी कौन अछि माने thumb impression. अच्छा
किंतु नोटिस रे साइन करछन
नोटिस रे कि उडा उडे कर देइथिबो ता पई उडे हां अब दस्तखत की माला ता नार की दस्तखत मार दी
ହାଜିରାରେ ମଧ୍ୟ ଦସ୍ତଖତ ମାରିଛି ଆଉ ଆଧରେ ନୋଟିସଟାରେ
ହାଜିରା ବି ଦସ୍ତଖତ ମାରିଦେଇ
ମକଦ୍ଦମା ଉପସ୍ଥାପନା ତା ଦେହରେ କିରୋସିନ କଟା ଫାଷ୍ଟ ସାକ୍ଷରକାରୀ ନୋଟିସରେ କିରୋସିନ କଟା ହାଜିରାରେ ମଧ୍ୟ କିରୋସିନ କଟା.
But however, you want it
So more time.
some more time to dispose of the case. We are granting you time. So it are kind of pending article.
Okay, direction.
पूरा reason टा लिखी देवे. As for the order dated 2010-25, the Land Council for the state has produced the 15 instruction dated so and so from so and so, wherein it is stated as follows. So in inviting you, एक पर्यंत को ये कर दो. View of the state of affair.
We got to completely exercise within 2 months.
We grant 3 months time for disposal of the 28A LA petition under sections 1 of the petitioner. Accordingly, the contempt petition is disposed of. Next.
Item 6.
I didn't see that it took more time to.
Inimas Magila,
I think so.
8.
Oh, short. Have you not received any instruction?
I have not received. I have oral instruction that there's some I send the notice for the hearing, but giving things. That's why there's some more time. Next week, 11th or 13th.
We are keeping it on 13th, so you obtain the instruction. And counsel for the state 6 for an adjournment till next week to obtain instruction regarding the compliance of the order dated so and so caused by dispute in WPC number so and so. This matter on 13th of November 2025. You are Mr. Rao Subhankar Rao. Mr. Subhankar Rao and counsel for petition is present. Yes.
Item 7.
These on the component that is the instruction received. Paper book upon an agent. पढ़ंतु आप आमे भी पढ़िनु अपन भी पढ़ंतु prepare time कथा कहंतु. This is a special bench and the criminal appeal is of the year 2000. We are in 2025, so if we write anything granting you time, so that would not be proper. Oh, अपन पढ़ंतु FIR टा भाई दियो पेपर ली FIR पढ़ंतु. केबेटू पेपर बुक रिसीव कलेनी 3 months back. Paper book केबेटू रिसीव कलेनी देखलो. 23 रे.
Anyway,
तो जहाँ भी हो
this
एटा कोन नहीं रख देइथिले ता भितर ना कोन आज सकाळ लिस्ट देखला परे बाहर कले धुळी आडी किन ना कोन. पढन ते FIR पढन. Wish to argue the matter? अच्छा ये बात है. Just a minute. फास्ट पेज टा पड़ा वाला ये प्रोसिक्यूशन विटनेस रो 15 उठो अछि आपण को पीडब्ल्यू पेज टा कोडे जी फास्ट पेज फाइन
सेकंड पेज में
ये जजमेंट टा कोन अधा कोन देई छी जो जजमेंट रो 33 परे आपण को पेज देखिना 26 पर 27 पेज पड़ गला जजमेंट राइट ये नंबर टा छाड़ो 26 पर 27 पेज पड़ गला
25, 27.
नहीं ये पेज टा 26 पर 28 एटा वो टू कंपेयर्ड बाय सो एंड सो करछंदी और डाकंतु से दी जण 3 जण जाको डाकन बी टू डू एस साहू बी सास्मल वकालत ना ये को आसंती एफआईआर को आसंती ये किए छे पीडब्ल्यू किए हाँ
2 माइल
अच्छा ये वाला पीडब्ल्यू 2 और पढ़ंतु कनक जोड़ा थाना सदर जिला सुंदरगढ़ अच्छा ये डिसीज ना कौन रेडियो डिसीज तला अच्छा ओके कौन स्कूल ना होजी थिपा पानी अच्छा
हाँ बेलबुडा हाँ क्रुसेड दंशन
देखिए कितने नंबर से
क्रुसेड दंशन है
पीडब्ल्यू 7 में
अच्छा 7 ओके हाँ कौन कहला अच्छा तो इसे ओरल डाइंग डिक्लेरेशन रहउची आई विटनेस की अछंती जजेस आई विटनेसेस की कोन पीडब्ल्यू 6
में
पीडब्ल्यू 6 पीडब्ल्यू 18
19
पीडब्ल्यू 19 ये ले तीनटा आई विटनेस नहीं हो ता ऊपर अपन कमेंट्स देबे जे हमें जेतेबेले जीबू खाली कहि दियंतु आई विटनेस ले
पीडब्ल्यू 6
6 18 और 19 ये ले तीनटा आई विटनेस ठीक तो ओरल डाइंग डिक्लेरेशन रो विटनेस की अपार्ट फ्रॉम द इन्फॉर्मेंट आउ की इन्फॉर्मेंट हला पीडब्ल्यू 2 हाँ ओरल डाइंग डिक्लेरेशन रो PW2 ଛଡା ଆଉ କିଏ କହୁଛନ୍ତି କି? PW7 ଏ ଦି ଜଣ ହଉଛନ୍ତି oral dying declaration witness
P-Rule
ଆଚ୍ଛା।
P-Rule 1, my lord.
କହୁଛନ୍ତି
P-Rule 1,
ଆଚ୍ଛା।
P-Rule 1, P-Rule 4.
ଏ ସବୁ oral dying declaration ଆଚ୍ଛା ଠିକ ଅଛି।
ସମସ୍ତଙ୍କ ଆଗରେ ସେ କରିଛି।
ହଉ ହେଲା 1 2 4 7 ଏମାନେ ହଉଛନ୍ତି oral DD ର witnesses ଆଇ witnesses ହେଲା 6 18 19 ଠିକ ତ?
My lord.
ଡକ୍ଟର କିଏ PM ଡକ୍ଟର?
P-Rule 16, my lord.
ପଳେଇ ଆସନ୍ତୁ 6 ନମ୍ବର ସାକ୍ଷୀକି ପଳେଇ ଆସନ୍ତୁ ଆଇ ୱିଟନେସ୍ କି ଯିବା।
Of the occurrence. Some more persons.
On the way.
ଏ 2 ବର୍ଷ ପରେ କଣ ପାଇଁ ତ ଡକା ହେଲା?
ଗଲା
ରିକଲ୍
ପରା।
କରାଗଲା ମିଳାମିଶା ହେଇଗଲା ନା କଣ? ସତାନବେରେ ଷ୍ଟେଟମେଣ୍ଟଟା ଦେଇଗଲା। No, we are not on that. The statement which he has made on 18697 and he was also cross-examined on that day. He has categorically stated that he has seen the assault by both the appellants, and one was assaulting by means of a budia, which is otherwise known as tangia, and the other is by a lathi, and they sustained injury, and then they were shifted to the hospital and died. That has been stated. So practically nothing has been brought out in the cross-examination, but statement has been how it was allowed and whether it is जो confrontation जदि ही पर था प्रथम दिन जदि से प्रकृत रे कहनी था 161 टा बाहर कलो और नाडा कोन पवित्र
पवित्र ठाकुर
हर कुमार नायक में पवित्र हर कुमार
पवित्र खाकुना
कुंवर
खाकुआ
रोना से रोना प्रधान it is. That is at page 279. Actually, more nama pavitra khar. ସତ୍ୟ ଯେଉଁ ଗତକାଲି 23ରେ ସୋମବାର ଦିନ ବେଳବୁଡ଼ାରେ ମୋର ଶଳା ସହଦେବ ବଡ଼କେ ଆମ ଗାଁର କଟରା ଯାଉଥିଲା ଆମ
जुरगुड़िया ढिप्पा
पुलिस
आंभे दुर्गुड़िया ढिप्पा पुलिया निकटरे आम गाँव शिव काल रक्ताक्त अवस्था पड़िथिलु
कौन बुद्धि पचारिबारु कहले ସେଇ ଡାଇଂ ଡିକ୍ଲାରେସନ
ପୁଡ଼ିଆରେ ଏବଂ ଧଡ଼ ରବୀନ୍ଦ୍ର କାଲ ଲାଠିରେ ମାରିଲେ
आई विटनेस ହେଇଗଲା ଡାଇଂ ଡିକ୍ଲାରେସନ
ପିଲା 2 ଜଣ ସାଇକେଲ ଧରି ସେଠାରେ ଛିଡ଼ା ହୋଇଥିଲେ
କୋଉଟା ସେଇ କୋଉଠି
ସୁନ୍ଦର ହାଇସ୍କୁଲରେ ପଢୁଥିବା ମେଘଡେଗା ଓ ମାଞ୍ଚନ ମାଝିର 2 ଜଣ ପିଲା ନା ସେମାନେ ସେ ଯୋଉ ୱିଟନେସ୍ 2 ଜଣ ଆଇ ୱିଟନେସ୍ ଏହାପରେ ମୁଁ ତଡ଼ାକୁ ଆସି ଖବର ଦେଲି ଆମ ତଡ଼ାକୁ ଆସି ପଡ଼ାକୁ ଆସି ଖବର
No, that appears that he is actually not right. Cross-examination inadvertently से बोले पचारने की से जिम्मे it's a genuine thing.
କିନ୍ତୁ ସେ
ଆରଟା ଦେଖିବା ବର୍ତ୍ତମାନ 6 ଉପରେ ଅଛୁ ନା ଏଟା 6 okay so now you go to the ଏଟା important ରହିଲା ତାପରେ next ହଉଛି 18 ନା 18 ଉପରେ ଆସନ୍ତୁ Mr. Pradhan, so far as 6 is concerned, we have verified that 161 is actually post-occurrence witness, but stated about the dying declaration. But in the court, he has posed himself as as an eyewitness and not stated about the dying declaration. But inadvertently, the defense counsel could not confront that previous statement. Subsequently, after I think it is 2 years,
years.
On recall.
he was on
Right.
recall, and that was rightly confirmed. He has admitted that yes, I have
Right.
not stated, and it's
Right.
Correct.
it
True.
appears it's a correct done. Okay, now you 18 PW 18. So he has not supported the process.
ଅଠର ଉଣେଇଶ ପରା
18.
ଉଣେଇଶ ଆଚ୍ଛା
18 and 18.
ଦୁଇ ଜଣ ଯାକ ତ କଲା
School going children.
ସେ ଯୋଉ ସ୍କୁଲ ଗୋଇଂ ପିଲା ଦି ଜଣ ଯୋଉ ଛିଡା ହେଇଥିଲେ
Right.
ଯୋଉଟାକୁ PW6 ଦେଖିଥିଲା
Right.
ତାଙ୍କୁ କହିଲା ତମେ ଥାଅ ଏଇଠି ଆମେ ଯାଉଛୁ ବୋଲିକି hopefully he was
ସେ ପିଲା-
alive then
Hmm?
he was then alive both of them happened
No, no,
Both of them
see,
record of that.
he was alive then
but these who are supposed to be the eyewitnesses to the occurrence, maybe perhaps in their 161 statement, they have stated so, but now they have not supported the prosecution case. So, 18 ଆଉ 19 ଏଇଟା ଯାକ ଏ ପିଲାଟାର 18 ବୟସ ହଉଛି 19 ବର୍ଷ ଆଉ ୟାର ବୟସ ହଉଛି 17 ବର୍ଷ PW19 ର. So both of them. So if this should be the state of affair, then eyewitness jana nahi. But
No, there is
now
no
the thing is eyewitness trial court has placed any reliance on any of these three witnesses. এই যে 6, 18 কি 19
Reliance on dying declaration.
no dying declaration
Right.
conviction is the
Right.
okay, all right, then you
And
come to one by one.
and leading to
PW2 କୁ ଆସନ୍ତି first.
one ବି କହିଛି
ନାଇଁ ତ?
1 mile.
ହଁ,
Yes,
ହଉ,
yes.
PW 1 mile.
one ବି କହିଛି
1.
ଆରେ କହୁନାହାନ୍ତି ଆପଣ
PW1
PW1
Wife of the deceased.
ହଁ
ହଁ,
ଠିକ ଅଛି
ଠିକ ଅଛି।
PW1 2 7 ନାଇଁ 1 2 4 7 and 16 ଏତିକି ଆପଣ କହିଲେ ତ 1 ରୁ ଷ୍ଟାର୍ଟ କରନ୍ତୁ. 1 is the that wife of the deceased person. Okay. ହଁ ପଢନ୍ତୁ.
I was in my house when Suresh came and informed me
ସୁରେଶ କିଏ?
Suresh sir not exempt.
Not exactly. All right, yes.
my husband Shivanas was assaulted and he also informed me that Madhu actively wasn't valid and
Just a minute, madam. Please wait. Please take your seat. even though the same has been scanned. The paper book has been typed by B to do, and it has been compared by S.S. Sahoo and B. Sasmal. We called all the three to the court and pointed out the same, and none could give any satisfactory explanation to us about as to why the page number 27 is missing from the paper book. Let the Register Judicial call for an explanation from all the three persons and submit the same before us. The explanation furnished by the three should be placed before us by Korgan. What a date given within 10 days. Go to people. 10 days. Guru Vardhan press code. Yes, you may go now. Yes. All read the video. No, ଆପଣ କୋଉଠୁ ପଢୁଥିଲେ ଆପଣ?
And accused economic control, identified all the injuries of my husband, Sivana, on the way while he was delivering.
So this is the information given by that Suresh, who has not been examined. All right, I went to the spot.
My husband was able to talk that time, and he told me that Akil Sundarmani Karlo and Ravindra Karlo got the injuries on his person. Injuries
By his person,
person.
Yeah.
I along with others brought my husband to the
District headquarters, DHQ.
treatment. The doctor, after the examination, declared my husband to be killed. I had already reported about the incident at the PS by the time my husband was brought to the hospital. One Christmas informed me while I was in my house about this incident. I cannot say the exact time when he gave me some information. He informed me about this incident in the afternoon in between 5 to 6 p.m. First, I went alone to the spot after my husband. Thereafter, other members of my family and villagers came to the spot. I had prepared tea for my husband before I got the information about this incident. Usually, I prepare tea for my husband every day in the afternoon. My husband was lying at a place which is at a distance of about 1 kilometer from our house. By the time I arrived at the spot, many persons had assembled there. We brought the deceased from the spot to our house in a cart, and from there we brought him in cart, and on the way we brought him in to the PHO hospital.
Net record to do.
I was examined by police during investigation of this case. In fact, there I stated before the IO that Suresh Maji, who said Dondasina, and
আচ্ছা রফিক পাঠান হবো
Rafik Pathan.
আচ্ছা ঠিক আছে রফিক পাঠান
and there you were flat on the road near Guruburia place it is not kept there. I had not given water to my husband, and that my husband
Was not
not incensed by the time I did there. It is not kept there. I had not asked anything from my husband, and that he had not told me the name of his assailant. It is not kept there. I am deeply shocked.
Yes, next.
I know good writing persons who are standing in the dust. I know the visit to Sivanath Kalo. The occurrence took place last year in the month of November in the afternoon. Visit to Sivanath Kalo is my cousin. I came to know from Prusel Anderson and Pavitra Anderson. Sorry, Pavitra Anderson, not again.
PW7 ला पुसेत.
Prusel Anderson.
Oh, I came to know from Purushit Dandasana is PW.
7.
अच्छा. ଆଉ ଇଏ ପବିତ୍ର ହେଇନି.
Pavitra not exam.
All right.
Even this incident, after reaching the spot, I asked my brother the name of his assailants, and he told me that I think Ravindra Kalo was
ନା ଇଏ କଣ ଶିବନାଥର ଭାଇ? ନାଇଁ ନାଇଁ ନାଇଁ. I asked my brother the name of his assailant. ଉପରେ କହିଲା ନା I know deceased as ନାଇଁ
cousin brother
ଉପରେ କହୁନି କିଛି. ସେ
cousin brother
ଏଠି ଅବଶ୍ୟ କହୁଛି ଯେ my brother. All right. ହଁ.
there. Ravindra Kalo caused the injury on him by means of lathi, and Sundaram Kalo caused the injury on his person by means of beer. We brought deceased Sigonath Kalo to DHO Hospital Sundargarh, and after examination, the doctor declared fatal. Cross-examination for detail. I cannot say the exact time when Crucial Traditional informed me about this incident. I was in my house when gave information to me about this incident in the afternoon. He informed me that my brother Shivnath had been assaulted. I had gone earlier after getting information about this incident to the place of occurrence. I was the place of occurrence is at distance of about half a mile from my house. Most of the villagers had already assembled at the place of occurrence. By the time I arrived there, as of the deceased hospital, I did not inform about this incident at the field on our way from the place of occurrence to the hospital. I gave information about this incident at the PS. I orally reported about this incident, which was ready to into writing by the police. I was examined by the police in connection with this case. I cannot say if the doctor of whom was present at the place of occurrence. When I reached there, it is not a capital. By the time I reached there, the place of occurrence, Sigonath was already there. It is not a fact that I did not ask any to Sigonath not inform me the names of the assailants, and that I am devoted falsehood.
So this man is the informant in the case, and he has not only stated about the dying declaration, and in the FIR also he has mentioned about this.
Right.
Oral, yes, oral dying declaration about. Now the next witness is PW4. Huh?
Right.
PW4. PW4 person.
PW3 also.
Huh?
3 weeks.
3 also. Similar.
No. They PW3 ମଧ୍ୟ କହୁଛି ପରା oral dying
PW3 କିନ୍ତୁ କ୍ରୁସେଡ ଡନସନା କଥା କହିଛି। କ୍ରୁସେଡ ଡନସନା ପୁରା ଏକ୍ସାମ୍ ନେଇଛି PW7। ତାହେଲେ ଇଏ କ୍ରୁସେଡ ଡନସନା ଏବଂ ସୁରେଶ ମାଝୀ ଆସିକି କହିଲେ ବୋଲି କହୁଛି। ହଁ
That's all right. So PW3 has also stated that he be spot and water was given to the deceased, and the deceased was asked about the names of his assailant, and he disclosed that these two appellants caused injury on his person by assaulting him. And thereafter, he was brought to the hospital and examined by the doctor who declared him dead. Okay, now cross examination পড়ন্ত।
Has not counted the number of persons who had attended there so far. I remember the same persons had attended. I had seen God injuries by Lydia on the person of Srinath Sayo. He had sustained full God injuries on his head. I cannot say the exact place of his head, and here he had
Got injury.
Got it.
we reached the hospital at about 10 p.m. in the
Night.
In the night. I cannot say the registration number of the vehicle in which we have to the place of occurrence is at a distance of about 1.5 kilometers from my house. I had not gone to the police station for giving report about this incident. It is not a fact that by the time I reached the place of occurrence, the Sivanat was already dead. It is not a fact that we brought the dead body in the vehicle to the hospital. It is not a fact that I have not asked Sivanat the names of his assailant, nor did he tell the name of his assailant. It is not a fact that I am literally hurt.
So the almost all the witnesses to the dying declaration, a suggestion has been given that by the time they reached, this man was already dead. So obviously, he could not have made the dying declaration. But they have denied that no, he was alive, and he has made the statement. And he, in that statement, he has specifically implicated these two appellants to be his assailants. And okay, now the other witnesses are number 3 পরে আউ কি রইলা
4 miles.
আচ্ছা
The son of the deceased.
Son of the deceased.
Son of the deceased.
just one of this তো 1 নম্বরটা হচ্ছে ওয়াইফ
Wife.
4
number.
নম্বরটা হচ্ছে সন
Son.
2 নম্বরটা হচ্ছে ভাই 3 নম্বরটা ইন্ডিপেন্ডেন্ট উইটনেস
Man.
পড়ুন চারটা পড়ুন
This is Sivanat father. This is Sivanat is my father. Rooster Grandson, Suresh Maji, and Rafi Pathan came to our house and informed that my father had been assaulted on the pony while returning from the street.
out of which Purushat has been examined as PW7 Suresh not examined Rafiq has also been examined
That is PW5 manner.
PW5 okay we'll go to okay
Came to our house and informed me that my father had been assaulted on the way while returning from the school. I went to the place of occurrence. I had seen 14 injuries to my back and here on the head of my father. I asked my father regarding this incident, and he told me that I think sugar mechanics caused the injuries on his head by means of Buddha. And Hafiz Pavitra Kayo
Caused injuries. Caused injuries.
Caused
means that he visited Sivanat the hospital, and after examination by the doctor, he was declared dead. And cross-examination by the defense, this incident took place when my father was returning from the school. I cannot say the exact time when I was informed about this incident by Crusade, but this incident took place while my father was returning from the school. Even my father was returning from the
That's good. That's it.
father, the place of occurrence, mother.
এটা ভুল
Mother.
যেটা
না না mother M লেখা আছে তারপরে
তারপরে এম লেখাইছে
above persons had assembled at the place of company. By the time we reached there, my cousin had successfully living on different parts of it. I did not go to the PS to report about this incident. I cannot say as to who reported about this incident at the fair. It is not because that I had not asked anything to my father, and that my father did not tell me anything, and that my father was already dead. By the time I reached there, I was examined by police to the place of
Hmm.
तर ये क्वेश्चन थे मतलब बाबा डेढ़ लीजिए
কি কইলা
ନାଇଁ ନାଇଁ cross examination କଲେ ମନା
Cross cross
it is not a
examination
fact
it's not a fact ନା
it's not a fact
It will 5 years.
it will 5% ଯିଏ କି ଇନଫର୍ମ କରିଥିଲା ତାଙ୍କୁ
yes
I also noticed even at travel, I think usual travel came to my shop and then purchased BD. And when I asked him,
where he was going
he was going in short Buffalo. Two persons came to my shop and informed me that Master Signath was lying on the way being assaulted, and I went to that place. I asked Signath about this incident, and he told me that both the accused person assaulted him and caused injuries by means of Priya and Lucky. I had seen three cups and very injuries on the head of Signath, which was caused by means of Priya. I had also seen injuries by Lucky on both the sides of the chest below the arm pit of Signath. I sent one patient to the house of Signath. His from his family members about the incident.
so this man is also a
Correct.
witness to the dying declaration so why are you omitting PW5 କହିଲେନି କାହିଁ dying declaration ବୋଲି କିବା କହୁଛି ଯେ ମୁଁ ଆସିଲି
ସେ ତ ଆସିଲା ତାପରେ ପଠେଇଲା ତାପରେ ଖବର ଦେବା
I went to that spot. I asked the deceased about the incident. He told me that both the accused persons assaulted him, caused injury by means of budia and lathi. I had seen cut injuries and I had also seen the injuries by lathi on the so and so. I sent so and so to the house of.
5, 6 and 7 from.
Huh?
5, 6 and 7. One ଯାଇଛନ୍ତି ସମସ୍ତଙ୍କୁ କହିଲେ
and ସେ ତ he doesn't know him he does not know them
Come to the cross examination. Let us.
unknown boys
By the time I reached at the place of occurrence, Okilo Palo, Dashananti Palo, Luchano Palo, had not happened to them. No, imagine the option is was exam taken.
दूसरी था ये दमयंती प्रताप है
But I reached the place of occurrence. I was the first to arrive at the place of occurrence. After getting information about this incident, I was present at the place of occurrence from 2:30 p.m.
Sivana
Was brought from the place of occurrence
to his house
from the hospital. I did not wait for PS for reporting about this incident. It is not a fact that I did not ask any Shivana at the place of occurrence, nor still it is saying in the names of his accident. It is not a fact that I am conscious.
Okay. 6 ତ ପଢିଲୁ ଆମେ ତାପରେ ଆଉ ଗୋଟେ ରହିଲା ଆପଣଙ୍କର ଯାହା କହୁଥିଲେ
Carlo. ଏ ଯୋଉ crusade
7 ନମ୍ବରଟା
27.
କଣ ବୁଝିଲେ
Also, this is not a fellow. I heard him call the doctor as my mother was suffering from dysentery. On the way, I saw Signath fellow was lying against the stand during injury on his head and the doctor who had been my
Mother.
about this incident, and the civil trial discovered that both the accused persons assaulted him and caused injury on his person. I went to the house of Sivanath Kanu and informed his family members about this incident. Plus a junction, I had been to call the doctor at about 4 p.m. That doctor was retired in Megadiga. I cannot say the name of that doctor. The doctor came to
Came in his scooter.
and I followed him in my bicycle and reached at the place of occurrence about 5 to 10 minutes after the arrival of the doctor at that place, who otherwise were also present at the place of occurrence. By the time we arrived there, I cannot say the names of the
Two boys.
I did not ask him to see what he is the doctor and it is the doctor.
Doctor who asked him.
The doctor told me to inform me about this incident in the house of Shivna. I went and informed him. I had informed him about this incident to the wife and son of Shivana. I had gone alone to inform this incident to the house of Shivna's family, and nobody had accompanied me. It is not effective there. The doctor did not ask any Shivna, and thus Shivna did not disclose the names of the both accused persons as his accident, and that I am reporting false.
You do 8 also.
8.
Minor.
Jinnu Naik.
এটা co-villager.
Huh?
Co-villager.
Tinnu Naik. Tinnu Naik.
Was done the law and also Shivanath Kalu after getting information about the incident from Pavitra, I along with 3 other villagers had then to the place of occurrence. I have seen cough and bloody injuries caused by means of Tangia on the fear of Shivanath Kalu. We gave water to Shivanath Kalu and thereafter I asked him about this incident and Shivanath disclosed before me that both the accused persons standing in the house assaulted him and caused the injury on his person. He was brought from the place of occurrence to his house. Thereafter, I returned to my house. As a Johnson, I got information about this incident at about 4:30 p.m. and I got information from the Pavitra that
Shiva Master was like.
Thereafter, I went to the place of occurrence, which had Bandasaran was present at the place of occurrence by the time I left there. It is enough to say that I did not ask anything to such a signal and that even after it is not for the names of both the and that I am getting.
So, what sort of injuries have been noted by the PM doctor?
PM doctor is
16.
oh inside.
Because 2 types of weapons were used as per the dying declaration. So one is a sharp cutting weapon, the other is a lathi.
Lathi.
So let us see that PW16.
Police liquidation I had conducted PM examination over the territory of Signal Trial, son of Signal Trial of Jampoda of village is Southern and this Sundagar and Hamza followed external inside of size and I
Into 1 cm, Pondit was present. Parietal. No, parieto occipital.
Carried to hospital region.
Like, 5 p.m., 1 p.m. One thief was present over left cyclical region of head. 1.5 cm below the first Roman tree inside the of size 4 cm into 1 cm.
TM.
One thief over left cyclical region of head.
1 centimeter below second ମାନେ ତଳକୁ ତଳ ତଳକୁ ତଳ
ତଳୁ
and 4 cm, 1 cm, only present over left occipital region of the head, 2 cm below the third. Height. Transition to
contusion
P. Then why that one cm into 1 cm on molar image
molar eminence of left side of cheek of face
cheek of face.
of I have because measurement is there was not and present in
subdural space
brain corresponding to external injuries on head on the left side. B. The spleen was lacerated on the lower border in zigzag manner, rupture, and associated with large quantity of liquid at and
clotted blood
Clotted blood.
clotted blood. All the injuries were antemortem in nature, and the same were sufficient in ordinary course of nature to cause death. The case of death was due to hemorrhage and shock, leading coma due to injuries to vital organs like spleen and the compression of brain. The injuries inflicted to the head, external injuries number 1 to 4, were homicidal in nature. Time of since death was within 12 to 36 hours. Executive 4 is my postmortem examination report, and Executive 4.1 is my signature. External injury number 1 to 4 are possible by the sharp side of an action. Cross examination for defense. The IO had not sent any weapon of the offense to me for my examination and opinion. 5 strokes are necessary for causing by 5 external injuries found by me. External injury number 5 may be caused by fall or dash. External injury numbers 1 to 4 are possible by sharp cutting weapon. External injury number 1 to 4 are possible two sharp cutting weapons
Bite.
by two sharp cutting weapons. Injury number 5 alone is sufficient for causing death. It is not a fact that I have not conducted PM examination properly.
So these corresponding injuries so far as incised wound that relates to that
tangia
tangia,
Yes.
and contusion is there,
lacerated
wound that is also possible by lathi. So the oral dying declaration that these type of weapons were used for assaulting the deceased is getting corroboration from medical evidence. Medical evidence does not rule out that no, by the either by the sharp cutting weapon or by lathi, these injuries are not possible. Rather, it confirms it. So, if how do you get over? Let us say the eyewitnesses have not supported. Two have not supported directly. One has also you have brought out that he has not stated above in the previous statement to have seen the occurrence. But there are number of witnesses who, on getting information about the incident from PW7 at least, they have reached at the spot, and all of them have stated that the deceased told about the name of these two appellants to be his assailants, and some of them have also stated that with what weapons the assault was made, and that is getting corroboration from the medical evidence. So it presupposes that though you have given the suggestion that he was dead by the time the witnesses arrived at the spot, but they all of them have denied no, he was alive, and then in a cot perhaps he was shifted, and then in a trekker he was taken to the hospital, where of course the had him dead.
So the keeping in view
So-
the distance, maybe that has a.
So oral dying declaration, if it is believable, then why it cannot be acted upon to convict this, to maintain the conviction? What is your submission?
Lordship, in this case, the competent witness discard this matter, Lordship.
Who are the competent?
Doctor of the Megada, जो जे थिया आइतले जे आसिकिरी बाटरे जे PW7 जाको डाकिया जो डॉक्टर डाकिया जाइतले ता मां को देखिया पई से माने ऑलरेडी प्रेजेंट थिले सिटी आसिकिरी से ता competent witness एग्जाम हेई ना
Not witness is not negative,
से
but the presence of the witnesses for one another at this spot is again corroborated.
seizure witness not
No, you leave the seizure. You leave the seizure. Please confine your argument, because as has been rightly submitted by the learned State Council, that the London trial court has also not placed reliance on the eyewitnesses account because they have not supported. One of them supported, but in the cross examination, yes, it has been brought out that it is.
And truthfully, he said also.
So now the entire case based on the dying declaration, oral dying declaration, and that has been reliance has been placed. How to get over it?
Lordship, there is a previous inmate there is, and so there is no at the time of dying declaration not present police and not
No, police कोठु आसीबे dying declaration हेला परे सेमाने खटियारे आनिले घरु शिफ्ट कले कोठी की ना
मेडिकल
हॉस्पिटल ले डॉक्टर डिक्लेयर कला डेट आ पुलिस तापर आसीबो ना जेतोले रिपोर्ट हला तापर आसीबो पुलिस आसिला बेलकु कोन पुलिस को प्रेजेंस रे डाइंग डिक्लेरेशन एठी दबार प्रश्न को उठुची ए जो सिचुएशन रे जोठी गां लोक माने तार फैमिली मेंबर्स माने जाई पहुंचुचंती एवं तांको आगे डाइंग डिक्लेरेशन होची सेठी पुलिस को आसीबो पुलिस तो इंटिमेशन ही नाही पुलिस पाखरे एफआईआर ही नाही एफआईआर PW2 देला परे जाई कि जो तार से लेखुची ना जे ମୁଁ ଏଇଆ ମଧ୍ୟ ଶୁଣିଲି ସେ ବି ଓରାଲ ଡାଇଂ ଡିକ୍ଲାରେସନ କଥା ମେନସନ କରୁଛି ଏବଂ
all are here not direct evidence is not there
अरे डाइंग are you mean to say you see the dying declaration can be a written dying declaration, suppose it is reduced to writing by the doctor, maybe in the presence of the magistrate also, executive magistrate also write it down, so that is, it depends upon that how much the decide how many time period what period the disease survives. So suppose he is in an injured condition, is hospitalized, and the requisition made, and or sometimes to the doctor to record it, or sometimes when the magistrate also comes record it, so that is in the form of a written dying declaration. But here there is no such scope, because by the time the affair was lost, the man is already dead. So that is how the case was also registered under 302. କାରଣ ସେ ଡାକ୍ତରକୁ କହିଲେ ଶିବ ମରି ଯାଇଛି, ତେଣୁ ତାପରେ ଇଏ ଆସିଲା ଏତଲା ଦବା ପାଇଁ, ତେଣୁ ସେଠି ଆଉ ମାନେ ରିଟିନ୍ ଡାଇଂ ଡିକ୍ଲାରେସନ ର ସ୍କୋପ ହିଁ ନାହିଁ. So is it your contention that on the basis of oral dying declaration no conviction can be sustained? Are you advancing an argument in that light? Then because it is not always possible, like this case, it is not always possible to record the dying declaration.
Yes.
It depends upon situations to situation. Okay, and suppose the man would not survive that much. By the time he may die on the way, like in
Like
this
That has
case,
happened.
that has happened in this case.
Mm.
So it depends, and sometimes the man may survive on at the time when he reached at the hospital, get treatment, and then there is scope, of course, for recording the dying
Dying.
declaration. And in such a situation, either the doctor may record it or the executive magistrate on requisition, he may record it. Here there is no scope. So we have to see that if we believe the oral dying declaration, which has been made by so many persons.
Only villagers, Narsi.
No, no, no.
Who else is there?
Who else would be there? Are you expecting who else would be there? The
Chance
occurrences
otherwise,
taken place.
chance witnesses, you mean to say, was going through by the side of the. No, why?
They were informed. Some persons
Yes.
who came first. One person has said that I came to the
Spot.
disease for first.
Yes.
I think that is
Right.
PW7.
No, PW5.
Rafik.
PW5. He is the person before he said that I am the first person.
Yes.
Then he
Sent
intimated somebody,
Came.
and then the family members came, and before the family members also same thing has been told. Then the deceased was shifted from that place to the house, and then house to the hospital. So where is the discrepancies regarding the dying declaration? The names are consistent, and it is not that it is such a time where the uh, deceased could not have marked the
Persons.
who are the persons who
Assailant.
assaulted him, because the occurrence has taken place at about
4:30.
4:30 after
In the
the
afternoon.
school hour. The teacher,
After
the
he
deceased was a
returned.
teacher.
Yes.
He was returning. So around 5 o'clock, let us say. So, and they are the co-villagers. The both the
Assailants are all.
the assailants are the co-villagers. So the identity cannot be doubted. The time of occurrence is such that there is no question of doubting the visibility factor. And apart from that, what you have stated, that there is some evidence of hostility between the. So who has stated about that? That there was some previous dispute between.
Some saying that, Lordship.
Because if that would be, then that is a double-edged weapon. You are advancing an argument that may be a ground for false implication. That may also be a ground to assault the deceased.
There is also 27 evidence that the seizure of
At whose instance?
at the instance of Sundaramani Kala.
That means appellant number 1. अच्छा, appellant number 1 instance से कौन recovery ହେଲା?
Budia.
Gave recovery weapon open para 12 minor
No,
Tangia.
judgment.
metal portion of Tangia from the house,
Tangia Tamila.
from his house,
Oh, from his house.
and one bamboo stick
Acha.
from inside the jungle close at the spot.
Of course, this axe was sent, and no blood was found, and lathi also, blood was found, but whether its origin not, and moreover, the doctor has also not been, these weapons were not sent. So even if we do not give much importance to the recovery of the axe and lathis, but again, if it is believed that these witnesses are all these 1, then 2, 3, 4, 5, 7, at least.
Lordship, kindly see the page 32 of the judgment.
Yeah.
Para 14, page 31, para 14 ଆରମ୍ଭ କରୁଛି. Thus, taking into account the aforesaid discussions, especially the dying declaration of the deceased and the recovery of weapon of offense MO1 and MO2 at the at, at the witness of Sundarmani, I am of the confirmed view that the prosecution has been able to prove its case against both the accused person beyond doubt. As regards the motive of both the accused persons, it was alleged by the prosecution that prior to the incident, there was a jhagada between the deceased and his brother Vishnu Kalu, father of accused Sundarmani Kalu, and in the Vishnu Kalu was found by the villagers. Similarly, there was a dispute between the deceased and Dhoba Kalu, the father of Kalu, over the taking of water for their irrigation purpose, and in that the said Dhoba Kalu had executed and undertaking not to create golmal, but however, when he again agitated the said matter during the relevant year, a meeting was scheduled to be held, but one day before the deceased was killed by the accused persons. But so far as aforesaid story is concerned, no evidence or the name.
Okay, so that part is rightly said.
Yes.
So it is just a
Story.
prosecution case, but it's a story because no witness has come forward to say about this. So let us.
Lordship, I have seen ଜଣେ କହିଛନ୍ତି ଯେ ତାଙ୍କର previous ଇଏ ଥିଲା ବୋଲି.
So that is it.
No, it goes in your favor. Let us say there is no evidence regarding the previous hostility, and if we recovery of this two weapons cannot be given much importance to because it has not been linked with the crime in question, in the sense that no blood was found and the doctor has also not examined it, so it's just a seizure. But again, what about this dying declaration?
And these nothing has been put to the witnesses showing their interestedness or otherwise to depose in the incident.
Why they would tell falsehood against?
Not a single question has been put to them that
Yes.
they had interest in the or they had any kind of animosity either with the deceased or they were friendship with the deceased. Nothing of that sort has come. Absolutely no question to any of the witnesses on that. Seems that the independence of the witnesses have been maintained.
High Court judgment रे लिखिଛନ୍ତି page 32 रे last three lines, no reliance can be placed on some documents which are so as to prove the motive of the accused persons. ତେଣୁ ଗୋଟେ document besides PW2 from possession it was seized ଗୋଟେ କଣ letter ଯୋଉଟା ପାଇଛନ୍ତି. So that goes that prosecution has failed to establish the motive. But again, in a case where either the prosecution relies upon the direct evidence or the oral dying declaration is consistent, then let us say that motive has not been established. So can that be a ground to disbelieve, discard the entire prosecution case?
ଗୋଟେ ଆର ଗୁରୁବାରକୁ ଆସୁଛନ୍ତି.
No, you see, we are posing this question to you so that
You can
you can prepare accordingly. It's not that we are pronouncing the judgment today. We are both of us have, neither you have gone it completely nor we have also. So when you place the evidence, so many things struck to our mind, which we place before you so that you can apprise us that why in these circumstances, when the learned trial court has mainly relied upon this oral dying declaration, why it should be disbelieved. Okay, because you can keep in mind that there is consistency between all these 5 or 6 witnesses about the author of the crime. Number two, the visibility aspect cannot be doubted because the time is such. Number two, that they were also known persons. Okay, and the assault part which has been stated by that this is the weapon, that is the weapon, that is also getting corroboration from the doctor who has conducted PM examination. He has noticed some incised wound. He has noticed a wound which is lacerated one. So obviously lacerated wound can be possible by lathi, and incised wounds are, he has rightly stated, sharp cutting weapon. Here is a tangia. So these are the things which are against you. So you are to meet it because that is the evidence reliance has been placed by the. So unless you overcome all these aspects, then you cannot succeed. So that is how we are asking you to prepare the case. We can take up this matter.
So what is required for you to prepare? The vital aspect which need to prepare is whether the presence of the witnesses at the scene of occurrence at different time could be possible, and who has seen what, all right, and how do they support themselves. That say if any discrepancy could be brought in that, probably you might have a case. Otherwise,
କାରଣ ଆପଣ ସବୁ ସାକ୍ଷୀ ଗୁଡାଙ୍କୁ ଗୋଟେ ଦଉଛନ୍ତି ପ୍ୟାଟର୍ନ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଦଉଛନ୍ତି ଯେ ଯେତେବେଳେ ଆପଣ ପହଞ୍ଚିଲେ ସେତେବେଳେ ଡିସିଜ୍ ମରିଯାଇଥିବ
only plea.
So that is the line which you are putting to all the witnesses to the oral dying declaration, but all of them have stated no, deceased was alive. So nothing further has been brought out by you from any other from any other witness that is the after the assault the deceased died immediately. So there was no scope to survive to make an oral dying declaration before all these witnesses. So if the death of the deceased at the spot immediately after the assault, you cannot bring it on record, then the oral dying declaration, which has been deposed by a number of witnesses and which has not been cited in the cross examination, that has been rightly, we can say that that has been believed by the learned tribe. And moreover, the submission which you are making, that since there is no written dying declaration, the oral dying declaration cannot be acted upon. It is not acceptable because in every case you cannot have an written dying declaration like this case, because the deceased on the way to the hospital died, and thereafter the doctor declared him dead, and then the matter was reported. So the question of recording of the dying declaration either by the doctor or by at the on the requisition of the police by somebody else like the executive magistrate does not uh, at all arise. Okay, so we don't think that you will find a decision that on the basis of oral dying declaration no conviction can be based, right? So you
the suggestion that you have put to the witnesses that it is not a fact that you have not stated uh, with regard to the confrontation made to the deceased who told has not been denied anywhere. That is that denial has not been confronted and found to be true. They have all consistently stated even in their earlier statement.
border tank declaration को आपण देखंतु तापरे डिसीजन कोन रही देखंतु एवं बाकी ए विटनेस गुडा को काहे कि डिसबिलीव हबो आपण देखंतु देखिनी प्रिपेयर होंतु अकॉर्डिंगली हला we are taking up this matter you are asking us to take up this matter on 13 आज ये होची 6 तारीख ना
Lordship.
तो था ठीक अछि Get number item 7
Item 7.
hard Panda land council you have been engaged as the amicus curiae
Lordship.
and an amicus curiae for the appellants they are on bail both the appellants
Lordship. Well,
no ଆପଣ କରୁନାହାନ୍ତି ଆପଣ ତ amicus curiae लो because it was filed I think by Mr. DP Dhon chamber ଥିଲା ବେଲ୍ ଯାଇଛନ୍ତି ନା ନାଇଁ ହଁ ଯାଇଛନ୍ତି କାରଣ ଆମ ସାଥିରେ
ବେଲ୍ ତ ଯାଇଛନ୍ତି 18 ଗଲେ 2018 ରେ
they are alive they were and they are also alive
yes
they have been released on bail since now acha lekhuntu the so also Mr. Sarat Chandra Pradhan led an additional standing counsel in part
since 2004
the London amicus curiae seeks some more time for preparation put up this matter on 13th of November 2025. How ki achandi?
Item 12.
No, what about item number 8? Somebody mentioned on behalf of Mr. DP Dhor on 23/9/25 and
is alive
to take up the matter after Puja holidays. Where is Mr. Dhor? And his associates are also not there.
Dasma Patra
Late.
Dasma Patra.
No, 2000 ମସିହାର criminal appeal and after 25 years we are taking and mention was made that we will argue the matter. We have recorded it in the order sheet.
This is his associate Mr. Dasma Patra is also present.
ଟିକେ ଖବର ଦିଅନ୍ତୁ କଣ ସବୁ ଜିନିଷ ଏମିତି
profit center disposal ଦେଇଥିଲେ statement
So that is of Dina. In the next matter, Mr. Dharanidhar Naik, senior advocate, was also there and he argued that recall petition and we rejected it and he also said that we will argue the matter.
ready the judgment was the
Mr. Dharanidhar Naik is present. in virtual mode. Yes.
Item 8.
Yes. Start the argument. You are just coming within 2 minutes and you start the argument. So go to the hearing. No, 18 way, but
I'll go to the factory.
Justice Rothnam Guru.
Thoroughly.
Take for previous orders will begin.
That was
Yes, PW 9 seems to be the eyewitness to the occurrence.
9, 10, and 12, Your Lordship.
9, 10, and 12. Out of which 9 is an injured.
Injured in the
Actually, it's injured eyewitness.
PW 9, PW 10, out of here.
12. 9 is the son, 10 is the wife, and 12 is the daughter of the deceased, Your Lordship.
The weapon of assault seems to be GI pipe.
GI pipe, Your Lordship.
So that version appears to be consistent. That the three eyewitnesses have stated that the appellant assaulted by means of a GI pipe to the deceased,
Yes.
and injuries are also there.
Injury is also that no postmortem doctor was examined because he was not available. Only the PW1 who treated first the
Injuries, the treating
injured,
doctor.
he was examined.
But corresponding injuries are there.
Corresponding injuries are there, but he took a plea in the 313 statement that while pulling me, my hand slipped and he sustained the injury by falling on the road, and there are branches of tree and also some stones are there. And that aspect was corroborated by DW1, Your Lordship.
Say DW. So, but you come to your that plea, particular plea which you have taken in question number 12.
12, Your Lordship. ଘଟଣା ଦିନ ରାତି 10ଟା ସମୟରେ ମୁଁ ଖାଇ ବସିଥିଲି। ବିଭୂତି ମୋ ଘରକୁ ପଶି ଆସି ମୁଁ କାହିଁକି ଜୋରରେ ଜୋରରେ ଟେପ୍ ରେକର୍ଡ ବଜାଉଛି କହି ମତେ ଗୋଟେ ଚାପୁଡା ମାରିଲା। ମୋର ଦୁଇ ହାତକୁ ଧରି ଘୋଷାଡି 2 ନମ୍ବର କ୍ୱାର୍ଟର ଆଡକୁ ନେଇଯିବା ସମୟରେ ସେ ପଡିଗଲା। ସେ ଗୋଟେ ଭାଙ୍ଗି ପଡିଥିବା ଗଛରେ ଝୁଣ୍ଟି ପଡିବାରୁ ତା ମୁଣ୍ଡ ଗୋଟେ ପଥରରେ ପିଟି ହୋଇ ଆଘାତ ଓ ରକ୍ତ ବୋହିଲା। ମୁଁ ତାଠୁ ଛାଟିପିଟି ହୋଇ ପଳେଇ ଆସିଲି। ଛାଟିପିଟି ହୋଇ ମୋର କ୍ୱାର୍ଟରକୁ ପଳେଇ ଆସିଲି। ମୁଁ ସଫେଇ ସାକ୍ଷୀ and the PW his wife also stated that while running away he fell down. While running away the deceased fell down. All the witnesses stated that he fell down.
No, what about you see, that's a suggestion has been given. Doctor has also stated that the injuries are possible by fall.
Fall, Your Lordship.
And you examine one witness, he has stated, but the eyewitnesses account is that it was not on account of fall, but it was by assault by that GI pipe and ଆପଣ ପ୍ଲିଟା ହଉଛି ମାନେ ଡିସିଜ୍ଡ 9 ନମ୍ବର ସାକ୍ଷୀକୁ ସରି ଡିସିଜ୍ଡ ଆକ୍ୟୁଜ୍ଡକୁ ଜବରଦସ୍ତ ଟାଣି
ନଉଥିଲା ବେଳେ ସେ ପଡିଗଲା।
ନଉଥିଲା ଭିତରେ ତା ୱାର୍ଡିଂ ହଉଛି ଯେ ତାର ହାତ ଖସିଗଲା। suggestion ଦେଇଛନ୍ତି ଯେ it is not a fact that while my father was dragging by holding the hand of Kula. We are in page number 64, page PW9. Suggestion টা দেখুন. Last 1, 2, 3, 5, 6, 7, 8. 8 lines from the bottom.
It is not a
Page 64. It is not a fact that while my father was dragging, my
By
father
holding
means
the hand of-
deceased. Deceased was dragging by holding the hands of Gokula means appellant. And appellant was trying to pull away his hand from my father's hand, being slipped away. ହାତ ଖସିଗଲା. My father fell down for a stone near quarter number 1, as a result of which my father sustained bleeding injury on the head, and other 3 injuries my father was due to his coming in contact with a fallen tree. ତାମାନେ ସେଠି ଗୋଟେ ଗଛ ପଡିଥିଲା ଏବଂ ପଥର ବି ଥିଲା, ଆଉ ଇଏ ଯେତେବେଳେ ଟାଣି ଟାଣି ନଉଥିଲା ହାତ ସ୍ଲିପ୍ କରିଗଲା, ଯୋଉଥିପାଇଁ ତାର ମୁଣ୍ଡ ରେ ଆଘାତ ହେଲା ଏବଂ ଗଛ ବ୍ରାଞ୍ଚେସ୍ ମଧ୍ୟ ଯୋଗୁ ହିଟ୍ ହେଲା. ଏବଂ that is how you have also some questions to the doctor.
Yes, sir.
And the doctor has stated that he has found bruises, lacerated wounds on the forehead, then left parietal, multiple fractures on the left parietal bone, so on so.
4 is the fatal injury.
Cross examination में lacerated wound are possible if the affected part comes in contact with some branches of the tree. Injury number 4 can be possible if the affected part of the head comes in contact with the stone by. This is your report. So suggestion which has been given by you has been denied. So just a suggestion, but some positive material, if you would have brought it by way of cross-examination, then that would have merely giving the suggestion and putting some questions, hypothetical things like, is it possible by this way, that way? Can you say that you have established your defense plea in that way? The defense case suggestion taking the defense case हबनी जो आई 3टा आई विटनेस जो टाइप रो स्टेटमेंट ଦେଇଛନ୍ତି जे घटनाटा एई टाइप रो हला एवं स्पेसिफिक स्टेटमेंट GI पाइप रे number of blows have been given on the vital part of the body. So there is no dispute that such statement is getting corroboration from the medical evidence. So unless you shatter this part and also brought some positive statement by way of cross-examination that which may establish your defense plea. Of course, that standard is by preponderance of probability, but something has to be brought out. Otherwise, by mere suggestion and that the doctor say that it is possible by this, can it whether the eyewitness account will be disbelieved?
DW1 was a witness to the charge sheet, but he was withheld by the prosecution, and we have examined him.
Because most of the witnesses have gone hostile. That is how they have taken. That is one part. But what about the injury? To an injured witness. If that story is held to be correct, then where is the scope of the injured coming there?
by same weapons. The same
If
weapons.
that is correct, that he fell down and met with a
Injured could not have sustained any injury. So that injured is
Yes.
examined by whom?
Same doctor.
Same doctor.
same doctor. So how he came and sustained the injury?
ସେ ଟାଣି ନଉଥିଲା ତା ହାତଟା ଖସିଗଲା
That is true.
ସେଠି ଗୋଟେ
ହେଇଗଲା।
ପଥର ପଡିଥିଲା ଆଉ ଗଛ ଡାଳ ବି କିଛି କଟା ହେଇଥିଲା
ସେ ତ ହେଲା।
ହେଲା ବଟ୍ ହ୍ୱାଟ
ୟାକୁ
ଆବାଉଟ୍
କାହିଁ ଇଞ୍ଜୁରି ହେଲା?
ସ୍ପଟରେ ସେ ଜିନିଷଟା ବି ଆଭେଲେବଲ କଣଟା ଏଇ ଯୋଉ ଗଛ ଡାଳ
ଅଛି।
ସେଟା
ହଁ।
ଇଞ୍ଜୁରଟା ବି ମାଡ ଖାଇଛି ସେଥିରେ।
So it is a coincidence that these are the circumstances of the spot. But at the same time, ନାଇଁ ଇଏ ତ କହୁଛି ନା ମାଡ ମାରିଲା ପରେ ସେ ପଡିଛି ବୋଲି
ପଡିଛି
କୁହାହଉଛି।
ପଡିଛି
So some of the injury could be that, but the first thrust was on the GI pipe.
PW9 କହୁଛି କି ସିଏ କେମିତି ନିଜେ ଇଞ୍ଜୁର୍ଡ ହେଲା।
ହଁ
ହଁ ସେ କହୁଛି
କହିଛି।
ତାକୁ
ସେ ଜିଆଇ
ଦିଟା
ପାଇପରେ ଯେତେବେଳେ ମୁଁ
ତାକୁ
ରେସ୍କ୍ୟୁ
rescue
କରିବାକୁ
କରାଗଲା
ଗଲି ମତେ ସେ ଜିଆଇ ପାଇପରେ ମଧ୍ୟ ହଟ୍ କଲା
ଆଚ୍ଛା
ସଷ୍ଟେନ୍ ଇଞ୍ଜୁରି।
ଆପଣଙ୍କ ପ୍ଲି ଅନୁଯାୟୀ PW9 ର ଇଞ୍ଜୁରି ବିଷୟରେ ଆପଣଙ୍କର କିଛି ଏକ୍ସପ୍ଲାନେସନ ଆସୁନି କାରଣ ଡାଇରେକ୍ଟ ଗଲେ ସିଏ ଟେପ୍ ରେକର୍ଡର ବଜାଉଥିଲା ତାକୁ ଇଏ କଲେ ତାପରେ ଟାଣି ନଉଥିଲେ ସିଏ ହାତ ଖସିଗଲା ସିଏ ପଡିଗଲା ପଥର ଉପରେ। ତ PW9 ଅନ୍ ଦ ହ୍ୟାଣ୍ଡ ଯୋଉ ଟାଇପ ର କହୁଛି ଭର୍ସନ କହୁଛି ଯେ ମତେ ମାରା ହେଲା ତାପରେ ଇଏ ହେଲା that is getting corroboration. On the other hand, your defense plea does not explain how this particular injured eyewitness, who is also the informant, sustained injury.
He sustained simple injury, your lordship.
କୋଉ ଜାଗାରେ ସେ ମାଡ ହେଲା ବୋଲି
ତା ପିଠିରେ
ଆଉ ତାହେଲେ could be simple injury ମାନେ ଏକଦମ ସିଧି jurisprudence about the
one lacerated injury is there. Two.
what is seen as grave injury in the naked eye on a person, in the medical jurisprudence, it appears to be a simple injury. But apparently, if you see, it appears to be very grave. But the grave injury under the medical jurisprudence is very of high degree. So we cannot expect all the injuries to be grave in nature.
This presence of DW1, has it been stated by the PW9? କାରଣ DW1 ର କେସ୍ ହଉଛି ଏମିତି ସେ ପଡିଲା thereafter myself and with the help of the son ମାନେ ହଉଛି PW9 took Vibhuti to his quarter and soon thereafter that was sent to FCI medical in an ambulance vehicle.
Yes,
What was the deceased? कौन काम करे?
FCI रे का
FCI रे ଅଛି।
ସେମାନେ ବୋଧେ କଲୋନି କ୍ୱାର୍ଟର୍ସ ରେ ବୋଧେ
କଲୋନି
ରହୁଥିଲେ।
ରହୁଥିଲେ।
ଇଏ adjacent ବୋଧେ
ये 6 से 7
ଟେପ୍ ରେକର୍ଡ ବଜେଇକି ବାରମ୍ବାର ଜୋର କରୁଥିଲା।
ଜୋରରେ ଚଲଉଥିଲା, ପିଲାମାନଙ୍କ ପାଠ ପଢାରେ ଡିଷ୍ଟର୍ବାନ୍ସ ହଉଥିଲା ବୋଲି ଇଏ ଆସି ତାକୁ କହିଲା ଯେ
ଆଗରୁ ବି ମନା କରିଥିଲା।
that was a regular happening. DW1 ମଧ୍ୟ ସେୟା
So
କହୁଥିଲା।
there was also huge dispute between them regarding the tape water, Your Lordship.
ହଁ ହଁ ସେ ପାଣି ୱେଷ୍ଟ କରୁଥିଲା। This was there and it is also the statement of DW.
DW1 also stated.
During course of law, it's all right, but number of blows seems to have been present.
ତାପରେ one more conduct is also here, it's very important. If that was only the thing that was dragged and the person came in contact with the stone and he sustained injury, this fellow fled away from the spot.
Your Lordship stated that the DW1 was the eyewitness to the occurrence. Your Lordship.
No, DW1 is giving the statement that the accused fled away from the spot. When the witness was very much present, DW1,
Yes.
and the accused was also there. So what prevented the accused not to be there and to help him, but to flee away?
It is a fact that Vikas Hutta, so and so, and Deepak Panigrahi was also eyewitness to the occurrence. IO तारा process them is
Hostel.
This is a hostile because it's a matter within the neighbors. Other neighbors have avoided.
Fantastic. ଘଟଣା ଯାହା ଯାହା ଅନ୍ୟ ସାକ୍ଷୀ ମାନେ କହୁଛନ୍ତି ସେଇ ସାକ୍ଷୀ ଦଉଛି twist କରିଛି ଏଠି ପୁରା totally ଆଉ the thing is that once you examine a prosecution witness as a defense witness, the prosecution cannot confront the 161
Yes.
so otherwise the state counsel could have confronted.
Yes.
So that statement is only can be utilized when that witness is examined as a prosecution witness. Otherwise, if you see that statement, he is an eyewitness and stated like the other eyewitnesses have stated. Deepak Ray, je पाठिखंड होची एथिरे मुक्तियुक्त होई तार क्वार्टर भीतर को जाई गोटे जीआई पाई पानी विभूति होता को पिटिवा में गोड़ाइला विभूति होता दौड़ी पलाई जे क्वार्टर नंबर 1 पाखरे पड़ी गले फल गोकुल सामल धरी जीआई पाइप रे श्री होतांकर मुंडू को गोटे पहाड़ देले जा द्वारा होतांग मुंड फाटी रक्त बहला से चेता शून्य गला या देखी स्वांशो करिया पई दौड़ी आसबारु गोकुल उक्त जीआई पाइप रे विकास पिठी को पिटिला पिटिवा द्वारा विकास होतार मध्य आघात पाई सेटार पड़ी गला विभूति होतांकर मुंड फाटी रक्त बाहरी बा देखी गोकुल भयर पिटी जीआई पाइप सहित घटनास्थल पहुंचवा विभूति होतार अवस्था गुरुतर देखी स्त्री एमाने His statement, obviously he came to the when the summon was issued.
Yes, he
came to the public prosecutor. Did not public prosecutor, so he did not decline. Now the defense brought him as a witness, but he stated it a totally different story than. अपन जो नहीं आइले गोटे लाइन नहीं आइले ही इज एन आई विटनेस माने नहीं जे ये जहाँ बर्तमान आज DW1 जो जहाँ कहूथिला से यही कहिछि
So he was inside custody since from bail 3.5 years. ଆଗରୁ କେତେ ଥିଲା ମୁଁ ଜାଣିପାରୁଛି।
ନାଇଁ
Well, can it be 304 part
final
1
form ଦେଖୁଛି this man was taken into custody on 12/11/1997. So 12/11/97 ସେ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଦେଖିଲ ବେଲ ଥିଲା ନା ଭିତରେ ଥିଲା ଟ୍ରାଏଲ?
He was on bail during trial, but
କେବେ ବେଲ ହେଲା? ରିଜେକ୍ଟ ହେଇଛି। accused in jail custody. Person devoid of merits rejected. Produced in custody. তারপরে বলি আচ্ছা এইটি বেলটা এইটি produced in custody put on the strength of advance petition filed by আচ্ছা এই কোর্টু বেল অর্ডার নেকি যাইছে 99 so 2/12 99 ରେ ବେଲ ହେଲା ତ 2/12 ମାନେ ଇଏ ହେଇଗଲା ଆପଣଙ୍କର 2 ବର୍ଷ ସେଠି ରହିଲା
11 ମାସ
ହଁ
11 ମାସ ପାଖ 2 ବର୍ଷ 11 ମାସ
ନାଇଁ 12/11/97
ନା 2/12/19 ରେ ବାହାରିଲା କଷ୍ଟଡିରୁ ବେଲ ବଣ୍ଡ
ବର୍ଷେ 11 ମାସ
ବର୍ଷେ 11 ମାସ
ବର୍ଷେ
ହଁ ବର୍ଷେ ମାନେ 2 ବର୍ଷ ପୁରା ହେଇନି 2 ବର୍ଷ ଧରି ନିଅନ୍ତୁ
2 ବର୍ଷ ହେଇଛି ନା
ହଁ
12/11/97 2/12/19 ହେଲାନି କି 2 ବର୍ଷ ହେଇଯାଇଛି ହଁ 2 ବର୍ଷ ତାପରେ then judgment was pronounced on
24/11/2000
acha 24/11/2000 High Court କେବେ ବେଲ ଗଲା 15/12/2003 15/12/2003 ମାନେ ଇଏ 3 ବର୍ଷ 5 years only 5 years ମାନେ how do you say that there was let us say the background how can you there was no premeditation in that way the deceased was playing that tape recorder जोरे साउंड बजुला ये आसिला मना कला तांको भितरे पाटितुंड हला परे ये आसिकिनी accused देइची death took place after 5 days I think
5 days old.
3
4 he was assaulted and 9
shifted to SCB red
the
there was a frequent court because of this conduct of the accused repeatedly the deceased was told him not to repeat the same
गोटे जो आपनकर देखंतु डिसीज रो इंजुरी जोटाक PW1 कहिछि प्रथमटा होछि गोटा बुइस्ट एटा होछि लेफ्ट आईलिड रे सेकंड इंजुरी इज ए lacerated wound that is a simple injury third injury is also a simple fourth injury टा left parietal जोटा की fracture जोटा की grievous है ଆଉ ସେଇଥିପାଇଁ ସେ SCB କୁ ଗଲା ସେଠି ଟ୍ରିଟମେଣ୍ଟ ହେଇକି so one of the injuries on the head it proved to be fatal and he died
and also evidence seems that only one fatal blow has been given other injuries are maybe out of the fall the bruise and all that
the cause of death due to head injury
that is the
that is there
se to कहउछन ना injury number 4 in ordinary course of nature is to cause death so that is the only injury which is possible and By the way, ବର୍ତ୍ତମାନ ଏ ଲୋକଟାର ବୟସ କେତେ? ଗୋକୁଳ ସାମଲ 25 ଇଏ ଜଜମେଣ୍ଟ ହେଲା ବେଳକୁ ତାକୁ ହେଇଯାଇଥିଲା 32 ଥିଲା।
32
ବର୍ତ୍ତମାନ ତା ଦେହରେ ଯଦି ଆମେ ଆଡ୍ କରିବୁ ଆଉ 25
57
may go on to 57. ରିପୋର୍ଟଟା କଣ ଆସିଥିଲା ମାନେ ଆମେ ଯୋଉ ଉଲ୍ଲେଖ କରିଥିଲୁ ଗୋକୁଳ ସାମଲ intimate that accused Gokula is alive, working as a pump operator in Nalco Pump House. After release on bail, Appellant resides alone in his native house at village Swanson using mobile number.
or I've seen service 57 মানে retired হয়নি।
My lordship, Lord, can you read 304 part 1, your lordship?
No, 04 part 1 it's all right, but
Minimum is 10 years.
minimum is 10 years. So
Lordship, there is a
Yeah.
judgment of the Honorable Supreme Court. It's mainly on glance.
Please recite the content. Citation.
1989 to SCC, page 207,
Hmm.
217.
Page get
Your lordship, 217.
Hmm.
But here the knife blow is given 3 knife blows. Second held, jod lekha hai set one. The appellant was entitled under section 4 of section 300 of IPC. Merely because 3 injuries was caused to the deceased, it cannot be said that he acted in a cruel manner. Under these circumstances, it would be proper to convict the accused under section 304 part 1 of IPC and direct him to suffer rigorous imprisonment for 7 years. The order of conviction and sentence passed on section 302 IPC set aside and fine if paid.
That is true, but the court has not dealt with one aspect of it. Minimum punishment is 10 years.
Your lordship, kindly say to invoke section exception section.
No, 302 we are not saying. We are saying about part
Just a minute.
1.
The minimum is 10 years.
Minimum is part 1, the minimum is 10 years.
Wait a minute. extend. Then, what? But the one which may extend to say, consider the extent of production. After the explain to the the little knowledge is the intention machine, but the extension with translation. Here, the case which you are citing, the occurrence took place in 1974, and it reached the Supreme Court and it was decided in 1989. So it was about 15 years after. Here, of course, it is 28 years. Yes, on the location, yes, age of his son. Small doing is not a decisive value. But what is important is the southern and non-parent is often the must have acted in a feat of them. Yes. Go with the continue to be the mentally second of the fit of the obviously. It's not that there was any breakfast from coolness arrived. Coolness arrived.
That's it. And
Other than this,
I will maximum give it some time. I will bring other decisions also.
you also find out 304 part 1 if we accept his contention about the sentence because he has remained in custody. As we have stated, it is for 5 years.
5 years.
So 5 years, some months. So now he is working as something in Nalco ଗୋଟେ ଗୋଟେ କାମ କରୁଛି
petrol pump ନାଲକୋ ନା କୋଉଠି?
Pump operator.
ଆଉ ବୟସ 58 ବର୍ଷ ହେଇଗଲାଣି ତେଣୁ let him bring some decision also in that light also you also examine and if anything special on the question of sentence also you can file an affidavit to that effect also you elicit that man also because in sentence point you can give it there is no problem sentence point যদি that can be considered also some circumstances which might not have been brought to our notice but ଖାଲି ଦେଇଛି କଣ ଯେ 57 ବର୍ଷ ସେ କାମ କରୁଛି ଯଦି ଏମିତି
ତାର
କିଛି
accident
ଆଉ
ଅଛି କି
କିଛି
ଆଉ
ଅଛି
କଣ?
ଅନ୍ୟାନ୍ୟ ଜିନିଷ ଯୋଉଟା କି that will have an impact on the also question of the sentence
We have sent letter, but he is not coming.
no that man is alive
Alive ଅଛି କିନ୍ତୁ ଆମେ letter
no
ଲେଖିଛୁ.
you can ask that man
Through IAC.
ask the IAC so that he can have the interaction
Yes,
with the council what is
ଆମେ
that
anticipate ବି ଆଣିପାରିବା କିଛି
Today
ଅସୁବିଧା ନାହିଁ।
I will intimate the IAC.
no the council who is conducting his case he wants to
Yes, yes,
fees
yes.
kotha alga
Yeah.
but he wants to help him in the sense so let him have an interaction with him
Interaction is
Yes, yes.
possible.
Today
so you arrange the interaction to have that interaction he is alive he is working
he is in duty.
Yeah.
he is in duty also that is
He is with an impression for us once I have granted bail and since long that
Bro,
is
that-
looking at it.
that is-
For us with that impression
that is the IAC report is that he's so we are also passing that order that you
yes, yes. Your Lordship, that
like
I will
element for
intimate.
interaction with the council.
likhuntu hard in part the Learning Council for the appellant submits that in spite of frequent communication being made by way of writing letters to the appellant, there is no response. And he wants to have an interaction with the appellant to ascertain some vital aspect of the case. Since the Learning Council for the state has recently produced a letter dated 10/12/9/2025 of IAC Bikrampur Police Station, which shows that the appellant is alive and is working as a pump operator at Nalco Pump House. Let the Learning Council for the state instruct the IAC Bikrampur Police Station to make necessary arrangement to have an interaction with the Learning Council for the appellant. In the meantime, put up this matter on 13 तारीख आसु 13th of November 2020 ତା ଭିତରେ ଆପଣ କହିକିନି ଗୋଟେ arrangement କରିଦେଇଥିବେ and thereafter you can file anything if you ascertain and also you also ascertain about the antecedent
Yes.
aspect. The Learning Council for the state shall also obtain instruction about the antecedent, criminal antecedent, if any. So also his conduct while on bail since 2003 granted by this court. है ना? Theta aspect आप ऊपर नहीं आ सकते, है ना? नाल्को पंप हाउस में नहीं नाल्को रे सर
Nalco service. Nalco FC.
ନାଇଁ petrol pump ନା ନାଲକୋ
नहीं
pump
Nalco
house.
house pump house ରେ
So
ସେ
he is an
ସେଇ
employee of
colony ରେ
Nalco.
ରହୁଥିଲେ
he's an employee of
Even
employee
earlier
of
he was an employee of Nalco.
ସେଇ
Because he was
colony ରେ
staying in the
ରହୁଥିଲେ
colony.
colony ର
conduct also the service of and
All that.
he is conducting service
with his employer.
with his employer. है ना? तीनटा aspect ने as a free copy of the order be handed over to the Land Council. during interaction, you ascertain those vital aspects which would have the bearing on the sentence. So that is up to you that how thing can be. So you must keep in mind that what are the things which are to be considered by the court while deciding about the sentence aspect. So on the sentence, it can be given to up to 10 years to life. And then what material, if it is brought, that can have a bearing on the question of sentence. So keep in mind, and while you can ascertain and bring it by way of an affidavit also. And he has also to bring it in the interest of justice. Let us consider both the side also.
Item 9.
All right, all right.
ଆପଣ item number
ଆପଣ କେତେ ନମ୍ବର?
12.
ହଁ. No, madam, you have been asked by Mr. Panda to argue the matter.
No.
No,
Then
time.
Only
what
time.
time no?
Yes, sir.
Permission. It's all right. Yes, you are ready in that.
Yes.
Argue the matter.
In the meantime, appellant note 2 already expired, madam.
Yes, appellant number 2 has expired. So it is already.
Appellant note 1 and 3, my lord. Appellant number 1 is the father-in-law, and 3 is the husband, my lord. The appellant's face trial and
Mother-in-law has expired.
mother-in-law.
Who is the husband?
Who is the appellant number 3, my lord?
କଣ ତା ନା? ରଙ୍କନିତ
Ronkonit, my lord.
ଏଲିଆସ ସନ୍ତୋଷ କୁମାର ସ୍ୱାଇଁ।
Matter.
ଏଟା
Yes.
And
498
one is that father-in-law.
Yes, my lord.
What is the conviction?
Life, my lord. Appellant's face
No,
trial.
conviction co-offense.
304B, my lord. 302, 304B.
302, 30B, 498. For DPR also. 201 also is there. Dead body disposed of.
Disposed after 4 days, FIR has been lost, my lord. Occurrence took place on 11/10/97, my lord, night, my lord, and the FIR has been lodged at 14/10, my lord.
How many years after marriage?
Marriage took place on after 6 months, my lord. 6 months after the marriage, as per the informed statement, my lord, marriage took place on 18/5, my lord, 97, and the occurrence took place on 11/10, my lord, 97.
Why you disposed of the dead body?
The appellant informed the informant, my lord.
Informant is the father.
Informant is the father, my lord. As per the statement of one Vijay Swami, my lord, he has stated, my lord, she can't see the
Who is he? Vijay?
accused, my lord. He accused, my lord. He also died, expired, my lord.
No. How can you take the statement of Vijay? Who is, when did this dead body?
You come to that your 313 statement because of the fact that you disposed of the dead body.
Right.
The real cause of death could not be ascertained, and you have not intimated the family members.
Yes, the
As per the statement of matlab Vijay he intimated the informational. He has
No, no,
taken
it's a natural. If it would have been a natural death,
Yes.
then the family members of the deceased could have been intimated, and they would have come, and in their presence, you would have disposed of the dead body.
he has
You come to the page number 53. See the last.
yes. ଦଶରା ଦିନ
ଦଶରା ଦିନ ପ୍ରତିମା means the deceased.
Disease my lord.
ଉପବାସ କରିଥିଲା
ରାତିରେ
ରାତିରେ ପିଠାପଣା ଖାଇଲା
ଚଲ୍ହା ପିଇଲା
ଚଲ୍ହା କଣ
ଚଲ୍ହା
ଦହି ଆଚ୍ଛା ଚଲ୍ହା ପିଇଲା ତାପରେ ପେଟ ମୋଡୁଛି କହିଲା ଆମେ ତାକୁ ଲୁଣ ପାଣି ଲେମ୍ବୁ ପାଣି ଦେଲୁ ଭଲ ହେଲା ନାହିଁ
ଶୂଳ ମାରୁଛି ବୋଲି କହିଲା
ଶୂଳ ମାରୁଛି ବୋଲି
ପେଟ କାଟୁଛି
ଆଚ୍ଛା
କହିଲା
ଶୂଳ ମାରୁଛି ବୋଲି କହିଲା ହଁ ତାପରେ
କହିଲା
ବେକ ଉଠାଇ ମରିଗଲା
ଦିନ 9ଟା 10ଟା ବେଳକୁ
ପୋଡ଼ିବାକୁ ନେଲୁ ଆରେ ମାନେ ଆପଣ ଯୋଉ ପ୍ରୋଜେକ୍ଟ କରୁଛନ୍ତି ସେ like he was he suddenly fell ill and died.
You immediately
How did you dispose of the dead body? এই ଟାଇପର ଯଦି କଥା ହେଇଥାନ୍ତା ତାହେଲେ ତାଙ୍କ ଘର ଲୋକ କରିଦେଇଥାନ୍ତେ ନା।
Yes, my lord. You will see, can see the page 59, my lord. 59, statement of a Vijay Swayam.
ସେ ଦଶହରା ରାତିରେ ଭାଉଜ ପ୍ରତିମା ପୂଜା କରି ଆସି ପେଟ କାଟୁଛି କହି ଷୋଳ ମାରିଲା କହି ଲାଗୁଛି କହିଲେ ତାପରେ ମରିଗଲେ।
ଆପଣ ଜଣକର
ମଲ୍ଲା ରାଉତ ପାଖକୁ ଫୋନ କଲି ମଲ୍ଲା ରାଉତ ଯୋଉ ଇନଫର୍ମାଣ୍ଟ ମାଇଲ
ସେ ଛାଡ଼ନ୍ତୁ ମ ପେଟ କାଟୁଛି ଆପଣ ଯଦି କହିଲା ମତେ ହଠାତ୍ ଏମିତି ଜଣେ ପେଟ ଇଏ କାଟି ମରିଯିବ ତାପରେ ଆପଣ ଡାକ୍ତର ପାଖକୁ ନେଲେ ତାପରେ ଡେଡ୍ ବଡିଟାକୁ ଡିସ୍ପୋଜ ଅଫ୍ କରିଲେ ସକାଳୁ ସକାଳୁ ତ without intimating the family members
ସେ ଫୋନରେ ପୋଡ଼ିଦିଅ କହିବାରୁ ମୁଁ
ଇନଫର୍ମାଣ୍ଟ କହିଦବ ବାପ ଘର ଲୋକ ଝିଅଟାର ଏମିତି ହଠାତ୍ ପେଟ ଟାଣିଲା ପୋଡ଼ି ମରିଗଲା ତାକୁ କହିବେ ହଁ ତମେ ପୋଡ଼ିଦିଅ ଆମେ ଯିବୁନି ବାପା ଘର ଲୋକ ନା ସେ କଣ
ସେ ରାଉରକେଲାରେ ଥିଲେ ସେ କହିବାରୁ ଯାଇ ମଲ୍ଲା ରାଉତଙ୍କ ଭାଇକୁ କହି ଦିନ 10ଟା ବେଳକୁ ଘରକୁ ଆସିଲି
You see, the problem in this type of cases is that since you have disposed of the dead body,
yes,
so admittedly the deceased was staying with you in your company, and burden of that discharge, that 106, is to be discharged by you, and now the fact that we could not know that what is the cause of death because postmortem could not be conducted. Now, the explanation given that must be appear to be a satisfactory one and probable one.
There is also a contraction statement between the witness and
No. Is it a natural death? Who decided that this is a natural death? If she was suffering from some problem, some ailment, according to her, and as you judged, she should have been immediately taken to doctor. You also decided that no. Who has decided that she is dead? How could you come to the conclusion that she is dead? Because you thought there is no sense, she is dead. So a doctor has to declare that the patient is dead. Minimum ଜିନିଷ ତ ଆପଣ କରିବେ କି ନାହିଁ ତାହେଲେ ସେଟା କାହିଁ ହେଲାନି ଡକ୍ଟରକୁ ଡାକି ଗୋଟେ ଚେକଅପ୍ ଟେ ହବନି କିଏ ଡିକ୍ଲାରେସନ କରେ ଡେଥର ନିଜେ ତାହେଲେ
6 months ଭିତରେ ଡେଥ୍ ହେଇଛି
Now, appellant number is 85 years your more.
We are more than that.
Already waited it in my lord.
Asking that
yes. In the contract statement of it, no, it is PW1 and 11.
We have not gone through the evidence.
Yes.
At the outset, we just put you a question: what is the cause of death? And 201 dekhila bale that we obviously we had an impression that perhaps something, and that you said that dead body has been disposed of. So without intimating if it has been disposed of. So IO ଆଉ ଯାଇନି ଶ୍ମଶାନକୁ ଯାଇ କିଛି ରିକଭରି କରିବା କିଛି
Recovery coach, there is no blood as per the forensic report. There is no blood, nothing else. As per the page
ନା,
109
ପୋଡ଼ିଦେଲେ ପୁରା ଭଲ କି ପୋଡ଼ି ଦେଇଥିବ ସେଠୁ କଣ ମିଳିବ?
no blood.
ତାପରେ ଯୋଉଦିନ ପୋଡ଼ିଲେ ତାର ସେମାନେ କେତେ ଦିନ ପରେ ଏତଲା ଦିଆହେଲା?
4 days. 11 night ହେଲା 14 day FIR ଦିଆ।
ତାମାନେ ଆପଣ ଚପେଇଥିବେ ତାଙ୍କ ଘର ଲୋକଙ୍କୁ
ନାଇଁ ସେମାନେ
ଜଣେଇ ନଥିବେ। ଆପଣ ପୋଡ଼ିଦେଲା ପରେ ବି ସେ ଆସିଲେଣି?
ସେମାନେ କହିଲେ 14 ତାରିଖରେ ଆସି ପହଞ୍ଚିଲେ, ଆସିଲା ପରେ FIR ଦେଲୁ। that is the statement of the informant.
ଜାଣିଲେ କେମିତି 14ରେ? ଆପଣ କହିଲା ପରେ ସେ ଶୋଇଗଲେ, ତାପରେ ଆସିଲେ।
ଆମ ଗାଁରେ ଥିବା ମୋର ବଡ ଭାଇ ଓ ଶ୍ୱଶୁର ଘରକୁ ମଧ୍ୟ କୌଣସି ଖବର ଦେଇନାହାନ୍ତି। 11 ତାରିଖ ଦିନ ଦଶହରା ରାତିରେ ଝିଅକୁ ପୁଅରୁ ବାହାର କରି ରାତି 9 ପାହୁଣୁ ପରିବାର ବର୍ଗ ମିଶି ପୋଡ଼ିଦେଲେ। ମୁଁ ଟେଲିଫୋନ ଯୋଗେ ଖବର ପାଇ ଆଜି ଆସି ଗ୍ରାମର ଏମାନଙ୍କ ସହିତ ପହଞ୍ଚି ଏତଲା ଦଉଛି। So the moment he came to know about all these things, he immediately gave the. So these things has been done according to what he have ascertained that ये लोग को कोटी रहा informant जी
ଭଞ୍ଜନଗର।
ये घटना है ला कोटी माने एक्सिस माने घर कोटी
belong to
भंजनगर माने घर
yes.
ଆଉ ये थिला
Informant
village name is Mandara near Bhanjanagara.
no
Yes.
informant भी तो भंजनगर ना
Yes, informant was staying at Raurkela.
staying at Raurkela.
हाँ but
Yes.
तारो लोक माने से कोची
PW1 ଯେତେବେଳେ ସେ ଆସିଛି ସାଙ୍ଗେ ସାଙ୍ଗେ ଆସିକି ପହଞ୍ଚି କହୁଛି।
ସପରିବାର ରହନ୍ତି।
PW1 is the
is an employee of Broadcast Steel Plant.
relative of the informant wife. He has stated she immediately came to the village malord. But you also consider the statement between contradiction statement between PW1 and IO malord.
No, who are the family members?
Family members PW1 malord.
You come to that.
PW1 page 60. About 3 years back, Pratima Budi, daughter
Alias Budi.
Alias Budi, the daughter of my sister, had married accused Rankanti 1 year after marriage. About 7:30 am, I got information from somebody that Pratima had been killed in her in-laws' house at Mandara. I reached Mandara within half an hour and found Panu, the husband of Pratima. The witness pointed out that his father and mother and the younger brother of the husband of Pratima were in their house. The mother-in-law of Pratima informed me that she died due to fall in the well, and I protested. Why, without informing us, they cremated her dead body, though we were residing in the little distance. While I was still near the house of accused Panu, police came and accused Vijay took me and police to the cremation ground, where the dead body of Pratima was still burning. Accused Vijay poured 2 buckets of water and with the fire. Police seized some bone flesh, bone and ash and took those with them. Accused Vipra, Rankanidhi and Sarojini brought out the articles given as a dowry during the marriage of Pratima, which police seized and brought to the police station. Subsequently, in my presence, police released the seized dowry articles in Jima of Malarautan, the father of deceased Pratima, who executed Jimana, executive 1, in my presence. In my executive 1 by 1 is in my signature. Accused Rankanidhi, in my presence, separated the other gold and silver ornaments which exclusively belongs to them and took them in Jima from the police in the presence of as per the demand. He came to the spot, my lord.
What the prosecution?
Prosecution. Pratima is a daughter of Sarojini, who is the daughter of the sister of my mother. I do not date on which I was examined by the police. Police examined me in my village and also at the police station. It is not a fact that I have not stated before the police that accused Sarojini informed me that Pratima died by falling in the well, and that I protested why the dead body of Pratima was cremated without informing us. That is my presence. Police seized dowry articles from the house of accused Ronko. That accused Vijaya and extinguished the fire of the cremation ground. That police burn flesh, bone, and ash from the cremation ground in my presence. That is my presence in Jimanama, where executed as accused Ronkonidi took gold, the silver ornaments belong to them in Jima. It is not a fact that subsequently being asked by the police, I put my signature in fake Jimanama in the police station. It is not a fact that I have never gone to the cremation ground and depositing falsehood. It is not a fact that I am a court bar, that I have got a long-standing enmity with the accused person as they belong to our rival party, that I know nothing and deposit.
ये जो confrontation कले जे आपण पुलिस पाखरे या कहनांती से कहनांती एगुड़ाक कहा जरिया आयो जरिया प्रमाण करेछन
You will see their statement has been recorded. 161 statement is not there, my lord. They are the witnesses, but their statement is not there, my lord. PW1 रो statement है मतलब.
देखा लिखुचंदी you come to page number 93 on 15/10/1997 I examined PW1 in the village jury, but I have not noted the time of such examination. How he ni conclusion.
I have not examined him in police station.
PW1 has stated the police came to on 12, my lord.
आपण कहले हम पचारछु आपण जो क्रॉस एग्जामिनेशन ने पचारले ना जे तमे एया कहनो से नॉट ए फैक्ट कहला तो इट रिक्वेस्ट टू बी अगेन प्रूफ थ्रू द आईओ तेणु आपणकर ये होची जे जो लाइन टा बाहर करचंदी सेठी पेज 93 रे little downwards जे I have not examined PW1 on 12/10/97 but he has stated that on 15/10/1997 he examined. I have not examined him at the police station. He has not stated before me that Sarojini informed him that Fatima died by falling well. That he proceeded. Acha.
PW1 has stated the police came on 12, my lord. What police is I have stated my lord, FIR has lodged 14 and he come on 14, my lord. And there is one statement of the PW1, my lord.
No, that is recorded on 15th February. Obviously 14
ଆସିଲା 15
ଏଇଟା 12 ତାରିଖରେ କୋଉଠି ହବ ଯେପର୍ଯ୍ୟନ୍ତ ଏଫଆଇଆର ପୁରା ହେଇନି ଏଫଆଇଆର ପୁରା ହେଇଛି ଆପଣଙ୍କର 14 ତାରିଖରେ ଆଉ ତେଣୁ ସିଏ
15 ସିନା ହବ
15 statement protested by so and so. This statement, of course, that has been done in that page 93, he has not stated before me that Sarojini informed him that
I have not examined PW1. You know, it's the page 93. I have the middle portion. I have not examined PW1 on 12/10/97. I have not given any written requisition to PW1.
No, you are leaving those portion. You are leaving those persons which you have confronted and proved through the IO. Yes. You come to third line from that page 93. So, third line, page 93.
Yes.
He has not stated before me that Sarojini informed him that Pratima died by falling in the well, that he protested why the dead body of the Pratima was cremated without informing them, that the police seized the article from the house of accused Ronko in his presence, that accused Vijaya extinguished the fire in the cremation ground, that the police in his presence seized so and so, that the accused Ronko took and so on so in his Jima. So this is the statement which he has not given. It is you have confronted him in that cross examination and proof. What are the other witnesses? Nothing. দুই কিছু করেনি তিন কিছু করলাম
11 minutes.
চারি বন্ধু গোটে গোটে ଯିବ ନା ଚାରି କିଛି ନାହିଁ ପାଞ୍ଚ କମତି କହିଛି ଦୁନିଆ ପ୍ରିଣ୍ଟରେ କଣ
medical officer.
I was counting in my contract to be my teacher. Sixala, I know the accused whose son. I do not know the other accused persons. Australia, South number Sakti. Kitchen I do a petition. No number kitchen. ଏଗାରଟା କଣ ଗୋଟେ କହିଲେ
11.
କଣ ଥିବ
He the villagers of the accused person.
କଣ
I know accused Panu Swai, accused Vijay Swai, and 3 others who are of my village. I know absent accused Sahadeva Swai, Sahadeva Naika, Gola Borada, Nakula Swai, and Panchu Swai of our village. I am the president of our Jubak Sangha of Mandara. The eldest son of accused Panu Swai, pointed the accused Ronka Swai in dock, had married the girl of village Mandara about 2.5 years back. After 2 to 3 months after marriage, accused Panu 2 to 3 times complained before me as a leading villagers that the wife of his eldest son was misbehaving with him and other member of his family and requested for my intervention. I went to the house of accused Panu and when before me the eldest son Vijaya, his wife, and accused Panu himself in presence of his daughter-in-law complained that his daughter-in-law was behaving as a chandi and showing disrespect to them. On the other hand, the daughter-in-law of accused Panu complained before me that she was tortured by her parents-in-law, husband and brother-in-law who were demanding to bring balanced dowry amount from her parents, and when she desired to go to her parents' home. Panu, his wife, and son were not desired to allow this girl to go to her parents' house within 5 to 6 months after the marriage of the eldest son of accused Panu. Her daughter-in-law died in the evening during Ashtami or Dasami Puja. The daughter-in-law of accused Panu had gone to Durga Mandap of our village with prasada and returned back. After some times we heard shout from the house of accused Panu. I along with the other went there to know the cause. The death of the daughter-in-law of Panu complained before us that the prasada she had been taken thrown out and she was assaulted by her parents-in-law, husband and younger brother of her husband, accused Vijay. We told them not to make any options and advised the daughter-in-law of the accused Panu to go and sleep. Early in the next day of morning, I got information from the guard of the top of or somebody else that is in our top a dead body was being cremated. I went there immediately and found accused Panu Sahi, accused Vijay, son of accused Panu, and some other persons who I do not know were cremating the dead body. I asked them why they were cremating a dead body in our top and whose dead body was cremated. accused Panu and his two sons told me that wife of the eldest son of accused Panu died in the night due to stomach trouble, and they were cremated her dead body. I returned to the village and took some villagers with me to show them how in my top the dead body of the daughter-in-law accused Panu was being cremated. About 10 a.m. on the same day, police came. You see, kind of that is the 12th, my lord. As per the statement of PW1, and police says the FR lodge 14 and he gone to the spot on 14, my lord. After 10 a.m. the same day, police came and ascertained from me if the top in which the dead body was cremated belongs to me, and seized as a kerosene bottle some bones earth from the place where daughter of the accused Panu was cremated and prepared a seizure list. Exhibit 3.1 and Exhibit 3/2 is my signature. Police went to the house of the accused Panu. I also went with the police. I found some broken glass bangles laying scattered outside the bedroom, and there were stains of blood on the wall and bedroom, and glass bangles and a piece of cloth from the house of accused Panu. And prepared the seizure list Exhibit 5, Exhibit 5.1 in my signature. I do not remember now if anything else were seized from the house of the accused or that day or subsequently. Crossing, sir. I have also a house in Sunamba Sahi Aska. My native place is Aska. Counted by students. For the last 15 years, I am staying at Mandara, being adopted to the maternal uncle. The name of my maternal uncle, natural father is Jagannath Panda. He is dead. I have documents to show that I am adopted to Gopal Krishna Panda. I cannot produce that document itself in court. I have married the daughter of my maternal uncle Gopal Krishna Panda. And it is not a fact that I have never stayed at village Mandara. It is not a fact that I have not the president of Juvak Sangha Mandara. It is not a fact that I am an antisocial and 41021 unlicensed revolver with 5 rounds of were seized from my possession. It is a fact that a case is pending in Aska court against me for unlicensed revolver and a cartridge. It is not a fact that I am involved in 10 to 15 criminal cases. I am a tractor owner and also doing business in fish and fish fries. It is not a fact that I do not have any business. I was examined by the police. It is not a fact that I have not stated before police nor anybody else what I have stated in my chief. The house of accused Panu Swai is about 100 meters from the house of my maternal uncle at Mandara. It is not a fact that I have never seen the daughter-in-law of accused Panu. It is not a fact that I have not stated before police that the elder son of the accused Panu married in village Mandara. And that 2 to 3 months after marriage, accused Panu complained before me 2 to 3 times as a leading villager that wife of his eldest son was misbehaving with him and other member of his family, and requested for my intervention. It is not a fact that I have not stated before police that I went to the house of the accused Panu before me, before his son, wife, and he himself in the presence of the daughter-in-law of accused Panu complained that his daughter-in-law was behaving like a chandi and showing disrespect to them. That the daughter-in-law complained before me in their presence that she was being tortured by her parents-in-law, husband and father and brother-in-law, who were demanding to bring the balance dowry amount from her parents. That she desired to go to her parents' house. That Panu, his son and wife were not inclined to allow them to go to her parents' house. It is not a fact that stated to police that within 5 to 6 months after marriage, daughter-in-law of accused Panu died. It is not a fact that I have not stated before police that one evening between Ashtami and Dasami, the daughter-in-law of accused Panu had gone to the Durga Mandap of our village. with prasada and returned back. That after some time we heard shout coming from the house of accused Panu. That I along with other went there to know the cause. That the daughter-in-law of accused Panu complained that the prasad she had taken were thrown away, and she was assaulted by her parents-in-law, husband, and younger brother-in-law, Vijay, that we advised them not to make a scene, and I told that the daughter-in-law to go and sleep. It is not a fact that I have not stated before police that early in the morning I got information from the guard of the top and somebody else that a dead body was being cremated in our top. That I went there and saw accused Panu, accused Vijay, eldest son of accused Panu, with other were cremating the dead body, and asked them why they were cremating dead body in our top and whose dead body.
This has been proved also through the IO. It appears that page number 94 that in fact he has not stated about all these things.
Yes.
Even PW 12 also contradictions have been
Yes,
proved. And PW 13 also.
Yes.
Second, they borrowed the dendro from something associated with this PW 11
Yes.
that has been brought out.
There is no one statement of the PW 11 my lord. 11 ର ମଧ୍ୟ one statement ନାହିଁ ଏଲସିଆର
ଦେଖିକିନି କହୁଛନ୍ତି ଏଇ ଜିନିଷ ଗୁଡା କହିଲେ 161 ନାହିଁ ବୋଲି କୋଉଠି କହିଲେ?
ଏଲସିଆର ମାନେ I have gone to the some documents ମାନେ
from you what it 161 ନା କଣ PW
11 name
the IO
ମଧୁସୂଦନ ପଣ୍ଡା.
Madhusudan Panda.
Yes, ma'am.
Have you verified the charge sheet witness or not?
ସାସିଟି ଅଛି କିନ୍ତୁ ତା ଷ୍ଟେଟମେଣ୍ଟ କୌଣସି ଜାଗାରେ ନାହିଁ.
No, verify କରିଛନ୍ତି ଫାଇନାଲ ଫୋନ
ସାସିଟି ଉଠିছে ତା ନାଁଟା ଅଛି କିନ୍ତୁ ତାର ଷ୍ଟେଟମେଣ୍ଟ ନାହିଁ.
ଅଛି ତ ଚାର୍ଜ sheet ରେ?
Yes, ma'am. ସାସିଟି ଉଠିছে 2 my lord.
ଟିକେ ସେଟା ନାହିଁ ନା? ଏଇଟା PW2 ଅଛି ମଧୁସୂଦନ ପଣ୍ଡା and ମଧୁସୂଦନ ପଣ୍ଡା ହେଲେ କେସ୍ ଡାଏରୀ ଦେଖଉଛି ମଧୁସୂଦନ ପଣ୍ଡା ଫାର୍ଷ୍ଟ ୱିଟନେସ୍ ଏକ୍ସାମିନ୍ କଲା ଇନଫର୍ମାଣ୍ଟ ତାପରେ ସ୍ପଟ୍ ଭିଜିଟ୍ କରୁଛି ମଧୁସୂଦନ ପଣ୍ଡା ଲେଖା ହେଇଛି ଏଠି examined him, he stated that SI Bhagat was shown the mango to them in the accused person's front. And so after there is no other statement. କିଛି ଲେଖା ହେଇଛି ବାକି ଆଉ କିଛି 161 ତ କାହିଁ ନାହିଁ।
PW1 ନାହିଁ କି 11 ନାହିଁ ଆୟ ଭେରିଫାଇଡ୍। ସେମାନେ ବି କହୁଛନ୍ତି ସେମ୍ ଡେ ମାନେ 12 ତାରିଖରେ ପୋଲିସ ଆସିଥିଲା ବୋଲି ତାଙ୍କ ଷ୍ଟେଟମେଣ୍ଟ, କିନ୍ତୁ ପୋଲିସ କହୁଛି 14ରେ ଆସିଥିଲେ।
ଆଉ ଗୋଟେ ଲେଖା ହେଇଛି ମଧୁସୂଦନ ପଣ୍ଡାର ସିଜିଓର ୱିଟନେସ୍ ହିସାବରେ 216 ରହିଛି examining also proof is and search ଅଛି। ଦି ତିନିଟା ଜାଗାରେ କେସ୍ ଡାଏରୀ ଲେଖା ହେଇଛି he is a witness to the search and seizure statement ଅଛି କିଛି Mr. Pradhan, ये जो दीटा विटनेस ये प्लेस करूचंती 1 नंबर और 11 नंबर ये दीटा को ये रो 161 स्टेटमेंट नहीं केस डायरी देखुची जे सीजर रो विटनेस बोली दी तीन जगह रे मेंशन है सो दैट इज व्हाई जहां भी से कहिचंती चीफ रे entire thing has been confronted and put to the that they have not stated anything. So that is right in that sense.
PW 13 member is the mother of the PW 13 mother of the receipt.
तारो अच्छा तारो स्टेटमेंट रो
PW
contradiction
13 ना 12 Mala
12
Raut.
is the informant.
Mala Raut.
Malat.
Mala Raut is PW 12. On 18/5/97, I got married my daughter Pratima Raut with accused Rankanidhi.
And he heard from his wife and she was happy number
এটা পুরো মারা হলো 12টা।
Deceased Pratima is my third daughter. use 13 number. ये 12 number 13 में
13. ये लेट रघुनाथ राउत रघु राउत वाइफ ऑफ लेट रघु राउत ये होची पाणु राउत
नहीं ये सरोजित राउत वाइफ ऑफ माला राउत
हां
सरोजित राउत वाइफ ऑफ माला राउत
मल्ल राउत
मल्ल
ओ ताले ये फादर
12 is the father name.
12 is father
Yes,
the father.
ये
13 is the mother.
13 is the mother.
ତାଙ୍କର ବି contradictions if you come to page number 95 and 96 of the paper book এটা both father-in-law, both the father and the mother of the deceased were examined as 12 and 13. They have at least stated that there was demand of dowry, and they got the information from the daughter, that is the deceased, that she was assaulted by her husband, father-in-law, mother-in-law, and they consoled the daughter not to lose the heart and assured her that they would get the things managed. So this is the, and on this aspect also there is no contradictions that has been
with regard to assault
with
also.
regard to assault. So now suppose let us, that part remains, that the marriage took place within, death took place within 6 months of marriage. The demand of dowry is there, the torture part is there, and they are the competent witnesses, father and mother, and they have stated that our daughter was complaining before us that the in-laws family members were demanding dowry, and they, she was also assaulted by, and then the death has taken place. So let us say 3 types of death. You are saying that it is a natural death, means suddenly he
pain in the
and
muscles.
got down. So to that effect, accept your statement that which you have written in the accused statement, there is no other material support. As has been rightly pointed out, at least if he has, see, fairly, your conduct would have been to uh, take him to a doctor. We did not take him to a doctor, and nobody has certified that she is dead. So you disposed of the dead body. So it was within your special knowledge, let us say, that how the deceased died. So if it is not an accidental death, or according to you it is a natural death, and you are failing that respect to adduce cogent evidence, since you are not disputing that the deceased was in your company, then what would be the inference? Demand ରହିଲା, period ରହିଲା 6 ମାସ ଭିତରେ, assault ରହିଲା, କାହାକୁ intimation ନ ଦେଇ dead body dispose of କଲେ, ଆପଣଙ୍କର ଖାଲି statement ରହୁଛି ଯେ ତାର ଏମିତି ହଠାତ୍ ତାର ଦେହ ଖରାପ ହେଲା, ପିଠା ନା କଣ ଖାଇ ଦେଇଥିଲା, କଣ ଖାଇଲା, ଲେମ୍ବୁ ପାଣି ଇଏ କଲା, ହଁ ଚଲା ଇଏ କଲା, ତାପରେ ଲେମ୍ବୁ ପାଣି କରି ଆମେ ଦେଲୁ, ତାପରେ ହଠାତ୍ ମରିଗଲା। ମରିଗଲା ପରେ ଘର ଲୋକ କହିଲେ ପୋଡ଼ିଦିଅ, ତାଙ୍କ ଘର ଲୋକ, ବାପ ଘର ଲୋକ। So if that is the case, then have you brought it out in the anything from any of these witnesses, from the either the father or mother, that yes, they were informed and they asked that to burn the dead body, will not go, will go afterwards.
Only husband and brother-in-law, they have statement, they have intimated to the
ଆପଣଙ୍କର ସେଟା ପୁରା କହିଲେ, ଆପଣଙ୍କର that is your statement in the 313 statement. ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା, ଆମେ ତାଙ୍କର ଜଣେଇଲୁ ଘର ଲୋକଙ୍କୁ, ବାପାଙ୍କୁ, କାହାକୁ ଜଣେଇଲେ ଆପଣ କହୁଛନ୍ତି?
ଇଏ ବାପାଙ୍କୁ ଜଣେଇଲେ।
ବାପାଙ୍କୁ ଜଣେଇଲେ, ବାପା ଇଜ PW12. So PW12 ର ଏଭିଡେନ୍ସ ରେ କିଛି ଆଣିଛନ୍ତି ତାଙ୍କଠୁ ଯେ ନାଇଁ ଆପଣଙ୍କୁ ଜଣା ହେଇଥିଲା, ଆପଣ କହିଲେ ନାଇଁ ମୁଁ ଯାଇପାରିବିନି, ମୋର ସମୟ ନାହିଁ, ଝିଅରକୁ ଜଳେଇ ଦିଅ, ଏମିତି କିଛି ଆଣିଛନ୍ତି? So ଯାହା ବି contradiction ଆଣିଛନ୍ତି,
80 my lord.
ହଁ
One page 82, my lord. One
Hmm.
Joyram Boxi, my lord.
Hmm.
Town of Persuram Boxi, it belongs to the village Jirul, my lord. Jirul means infamous village.
Hmm.
At his instant, the present affair has been lodged.
No.
Yes.
You see, you come to page 80.
Yes.
Father statement.
Yes.
ସେ କହୁଛି ଯେ on 14/10/97 paragraph 2.
Yes, my lord.
At about 5 p.m. I went to the house of accused Panu, asked him, his sons and wife, how my daughter. All of them replied that Pratima committed suicide by jumping into the well in the night. When I asked them why they did not inform my brother-in-law and me and the police before cremating her, they replied that as it was night, it was not possible to intimate us regarding the death of the Pratima. I told them that the well in their backyard is so small that a bucket would in much difficulty would enter into it. How my daughter committed suicide jumping into that well. Police. So this is the, you see,
Yes.
this is not your plea. What you have stated before the father on his arrival in your house, that is not your plea. You are taking some other plea. That ତାର କଣ ପିଠା ଖାଇଦେଲା, ତାର ଇଏ ଖାଇଲା, ବାପ ଯେତେବେଳେ ଆସି ପହଞ୍ଚିଲା ତାକୁ କହିଲା ଆପଣ ଝିଅ କୂଅ ଭିତରୁ ଡେଇଁ ପଇଲା ଆଉ କୂଅ ଭିତରୁ ଡେଇଁ ପଇଲା ସୁଇସାଇଡ କଲା। ସୁଇସାଇଡ କଲା ପରେ ଆମେ ନେଇକିନା ଆପଣ ଇଏ କଲୁ, ସେ କହିଲା ତାହେଲେ ଜଣେଇଲନି କାହିଁକି? ଇଏ ନା ରାତି ହେଇଥିଲା ତେଣୁ ଜଣେଇବା ସମ୍ଭବ ନଥିଲା, ଆମେ ନେଇ ପୋଡ଼ିଦେଲୁ। ତାପରେ ସିଏ କହୁଛି ଯେ କୂଅଟା ଗୋଟେ ଏମିତିଆ ଇଏ ଯୋଉଠିକି ଖାଲି ଗୋଟେ ବାଲ୍ଟି ହିଁ ଯାଇପାରିବ,
ସ୍ମଲ୍ ବକେଟ୍, ସ୍ମଲ୍ ବକେଟ୍,
ଛୋଟିଆଟେ ଇଏଟେ, ଜାଣିବା ବି ସମ୍ଭବ ନୁହେଁ ଡେଇଁକିନି ସୁଇସାଇଡ କରିବ। ତେଣୁ that is his case, and on this point you will find, if you come to the IO statement, there is no such contradictions in that IO statement. The mother has also come with the father. ନା ନାଇଁ ମା ଆସି ନଥିଲା, କେବଳ ବାପା ଆସିଥିଲା।
ଦି ଜଣ ଆସିଥିଲେ।
ଦି ଜଣ ଯାହା ଯାଇଥିଲେ। ମା ବି କହୁଛି we are reluctant to send our daughter with her father-in-law, but the relation and so on so staying at home persuaded us to allow our daughter to go with the father-in-law. On the insistence of the father, accused Panu to so and so, we borrowed the same from Khalirao. Then we promised to go to the house of the accused, also the balance amount, and inform him that we bring our daughter then. About 1 month and 10 days after this one, so left Raurkela with my deceased daughter Pratima, we received the phone call that my husband had gone to B shift, then he returned so and so. PW1 informed over phone that Pratima was killed by so and so.
The PW was silent. One is silent about intimation.
About?
Silent, the intimation to the PW 13, my lord. Intimate. PW 13 goes to intimate level.
All right, you have intimated.
Yes.
Before the, yes, how could you cremate the body? Nice, Raukla Routhle, even if he was in Raukla, some of his relations were in the village. Some village and gentries has to be there, police is to be there, and he could have cremated.
ତାଙ୍କର ସେ କହୁଛନ୍ତି ଆମର ଇଏ ସେଇଠି ରହୁଥିଲେ ବୋଲି।
ଅନ୍ୟମାନେ ସବୁ ପାଖରେ ରହୁଥିଲେ।
Relative PW1 and 2.
Many people were there.
PW1 is just staying.
So that is the reason. ବାପା ସିନା ରାଉରକେଲାରେ ଇଏ କରୁଥିଲା ଏବଂ PW13 ସେଠି ରହୁଥିବ, but what about the other family in relations? ଆପଣଙ୍କର
ପ୍ଲିଟା
ଅଲଗା ରହୁଛି। କାହାକୁ କହୁଛନ୍ତି ସୁଇସାଇଡ କଲା, ଆପଣ ପ୍ଲି ନଉଛନ୍ତି ପିଠା ଖାଇକିନି ପେଟ ଗଣ୍ଡଗୋଳ ହେଇଗଲା, ଲେମ୍ବୁ ପାଣି ପିଇଲା ମରିଗଲା ହଠାତ୍।
ସେପଟେ ଡେଡ୍ ବଡିଟା ବୋଧେ ତାର ଗୋଟେ ପାଣିରୁ କୋଉଠି ଗୋଟେ ବାହାର କରିଛନ୍ତି ନା କଣ?
ନାଇଁ
ଆଉ?
ପୋଡ଼ି ଦେଇଛନ୍ତି କିଛି ନୁହଁ
ଆଉ ସିଧା ପୋଡି
ପୋଡ଼ି ଦେଇଛନ୍ତି ଡେଟ୍
ନାଇଁ ଆକୁ କହୁଛନ୍ତି ଯେ ପାଣିରୁ ବାହାର କଲା
ହଁ
ପରେ
ହଁ
ତାପରେ ଆମେ
Yes.
ଇଣ୍ଟିମେସନ ଦେଲୁ।
ପାଣିରୁ ବାହାର କଲା ପରେ କହୁଛନ୍ତି ପରା
ହଁ,
କୋଉଠି
ମାନେ
ପାଣିରୁ ବାହାର
କୂଅ ଭିତରେ ପଡିଥିଲା, କୂଅ ଭିତରେ ପଡିଲା, ପାଣିରୁ ବାହାର କଲୁ, ସେ
that is
ମରିଯାଇଥିଲା।
only a story,
ହଁ।
nothing.
ବର୍ତ୍ତମାନ ଯେହେତୁ ଆପଣଙ୍କର ଉପରକୁ ବର୍ଡନ ସିଫ୍ଟ ହଉଛି 106 ଅନୁଯାୟୀ,
yes ma'am
ଏଇଟା ଆପଣ ତାକୁ କୋଉ ଷ୍ଟାଣ୍ଡାର୍ଡ ଅଫ ପ୍ରୁଫ ରେ ଦେବେ ସେଗୁଡାକ ଏଇ ଯାହା ମ୍ୟାଟେରିଆଲ ଆସୁଛି, ହାଉ କ୍ୟାନ୍ ୟୁ ସେ ଦ୍ୟାଟ୍ ୟୁ ହାଭ୍ discharged that burden? 106 says that it was within your knowledge. When it was within your knowledge, the burden of proving the fact is upon you. So
Since preliminarily the prosecution is discharging the liability.
prosecution is discharging the duty by saying that he was in your company, she was previously tortured, she was you are demanding money
Money
to
has
so
been
and so,
paid.
and the death was not intimated.
Yes.
So all these aspects were proved by the prosecution.
Yes.
Now the main thing is that she was in your company, and you are to say that how she died. Your plea that at one point of time when the family members came, that she jumped into the well, committed suicide. In your trial, you are taking a different plea. So that shows that it is inconsistent.
actually मतलब one Joyram Bakshi of the informant's village my lord, he was working as a police my lord, as he invested the present FIR has been lost my
No, whatever.
how
No, whatever FIR has been lost even after 7 days. Because they were not
Yes.
intimated, they intimated only after 7 days. May it be through a police or whoever. Did you discharge your part of liability? When the daughter, does it look apparent that yes, she has some element of which she died? ଜଣକୁ ପେଟ ଦରଜ ହେଲେ ଯଦି ମରିଗଲା ତାପରେ ତାକୁ ଡାକ୍ତରଖାନା ନେବେ କି ନାହିଁ? Where have you exhibited your conduct?
How you become so sure that she has died? That is the main
Yes.
question which has been posed to you, that you burned the dead
Yes.
body.
next verify
ମାନେ ସେ ଯୋଉ ସୁଳି ମାରିଲା କି ଯାହା ବି ମାରିଲା ତାପରେ ସେ ମରିଗଲା. You decided and cremated within half an hour.
next morning they have decommitted the dead next morning.
Next morning,
Whatever.
without
Rather,
intimating anybody who are even staying in that village. The relations of the deceased who are staying, they belong to the same village. You belong to that Bhanjanagar
Mandara.
Thanaro.
ଗାଁର କାହାକୁ ବି ଡାକିଲେ ନାହିଁ ଯେ ୟାର
12-15 ଜଣ ଗାଁ ଲୋକ ସବୁ ପଡିଆକୁ ଯାଇଥିଲେ.
ନା ଡାକିଲେ କି ଯାହାର ଏମିତି ହେଇଛି ଡାକ୍ତରଖାନା ନେଇଯିବା, ଆଉ ଗୋଡି ଦେବା ପାଇଁ ତ ସମସ୍ତେ ଆସିଲେ, ତ ମିଶିଗଲେ ଗୋଟେ ଗାଁଟା ପୁରା ଆଉ.
ସେ ଲୋକଗୁଡା ସବୁ 201 ରେ ବୋଧେ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲେ, ସବୁ ଆକ୍ୟୁଟାଲ ହେଇଛନ୍ତି.
ଆଜ୍ଞା,
ତାଙ୍କର ପ୍ଲି କଣ?
ଇଏ brother in law may also face the one she was also convicted under 201 madam.
Who?
मतलब ବିଜୟ
ନାଇଁ ଯୋଉ ଗାଁ ଲୋକଗୁଡାକ ଯୋଉ
ସେମାନେ ଆକ୍ୟୁଟାଲ ହେଇଛି.
ତାଙ୍କର ପ୍ଲି କଣ ଥିଲା, ମାନେ what was their plea? Certain statement.
18 ଜଣ ନା କେତେ ଜଣ ଥିଲେ? କେତେ ଜଣ
ଗାଁ ଲୋକ ସେ ପ୍ରସ୍ତୁତି
10 ଜଣ.
Total 10.
ତାଙ୍କର କି ଟ୍ରିଟମେଣ୍ଟ ହେବ?
Statement आधे नहीं I want you bring in a this trial and they were acquitted. Deflecting step mountain.
It in 88. So.
Hmm?
This year, 8.
Oh, so
this year,
if ମାନେ ପଣ୍ଡିତ ମାନେ ସବୁଗୁଡା ଏସବୁଗୁଡା କାଢିଦେଲେ ଏଇ ଆକ୍ୟୁଟାଲ ତାଙ୍କର 313 କଣ ଦରକାର
ଏଇଟା ବି ଅଛି ବିଜୟ କୁମାରର ତାପରେ ଏଇଟା ଅଛି ରଙ୍କନିଧିର ଏଇ 4 ଜଣ ଏକ୍ୟୁଜ ଯୋଉଟା କନଭିକ୍ସନ ଅଛି ସେଟା ଦେଇକି ଛାଡିଦେଲେ ସରୋଜିନୀ ଆଉ ପାଣ୍ଡୁ ଆଉ କାହାର ଏଲସିଆର ୟାର ଅଛି କି ପଠେଇ ଦିଆଯାଇଛି ଅଛି ଦେଖିଲେ ଏକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ କଣ ଅଛି ଅରିଜିନାଲ ଜଜମେଣ୍ଟରେ
ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ରୁ ଜଣା ପଡୁଛି 10 ଜଣ ଟ୍ରାଏଲ ଫେସ୍ କରୁଛନ୍ତି
ଆଜ୍ଞା
10 ଜଣରୁ ଇଏ ହେଲେ 3 ଜଣ ଯୋଉମାନଙ୍କୁ କନଭିକ୍ସନ ହେଇଛି
4 ବି କନଭିକ୍ସନ ହେଇଥିଲା ଫର 2 ଇୟର୍ସ ମାଇଲ
4 କୁ କନଭିକ୍ଟ
ହଁ 4 ଟୁ କନଭିକ୍ଟେଡ ଫର 2 ଇୟର୍ସ
ଆଉ
5 ଟୁ 10 ପର୍ଯ୍ୟନ୍ତ ଆକ୍ୟୁଟାଲ
5 to 10 acquitted.
5 to 10 acquittal 5 to 10 acquittal ସେ ଯୋଉ ଫାଇଣ୍ଡିଂ ଟା କୋଉଠି ଅଛି ସେମାନଙ୍କୁ ଚାର୍ଜ ହେଇଥିଲା ଓନ୍ଲି 201 4 ଜଣଙ୍କୁ ଚାର୍ଜ ହେଇଛି 498 34 304 ବି 34 302 34 so on so 4 that the other accused persons
only 20
अच्छा अच्छा वो सेटा वो
अलगा
छाड़ी ଦେଇଛି 232 ରେ ଛାଡି ଦେଇଛି
ଓହୋ 232 ରେ ଛାଡିଦେଲେ
हां
Serial number 5 to 10 since acquitted on the 332
232 were charged under 201 evidence किसी आसी नथिବ ସେ ଆଉ ଦେଖିବାକୁ ଛାଡି अच्छा no accused statement नहीं but should I see that even
two thirty accused statement ହବନି 232 ରେ accused statement is not coming before accused statement ହବନି
after taking the evidence and examining the accused
କହିଛି
and hearing the prosecution and the defense and the command, the judge considered there is no evidence of acquittal.
232 ରେ
and ତାପରେ
ତାର accused statement ତ ଅଛି
statement ହବା କଥା
ଅଛି
ଏଟା କେବେ acquittal କଲା ଦେଖିବା 232 ରେ
order dated 9/7/2001
ସେଟା ଅର୍ଡର ସିଟ୍ ରେ ହେଇଥିବ ତାହେଲେ ଅଲଗା
order କେତେ କେବେ କହୁଛନ୍ତି ଡେଟ୍ ଟା
order dated 9/7/2001
9/7/2001 ବାହାର କର No.
230 ରେ ତ 97 ଏମିତି ହବା କଥା ନୁହେଁ hard 232 CRPC varies the case record examine the accused persons କହୁଛି hard the prosecution
The accused are the prosecution and even there is no evidence against one and so
very summary procedure this is not the procedure total reasoning ତ ଦେବା ନା କହିବ ତ there is no evidence against that there is no material advocate for the defense files a petition for grant of time to ethics for statement of 330 on the ground that the accused persons will be
ଏଠି କ୍ଲିୟରଲି କହୁଛି ମାନେ ଯୋଉ 9/7/2001 କହୁନାହାନ୍ତି ତା ଦେହରେ ଗୋଟେ ଲେଖୁଛି period the case record, examine the accused persons.
What
So
is that?
statements means that there must be some thing which has been examined ମାନେ recording
ଆଉ ତ କିଛି ନାହିଁ examination ର।
ଆଉ ତ କିଛି ନାହିଁ। ଦେଖି ତମ ଫାଇଲ ଟା ଦେଖି।
But he is acquitted 232. 201 is an offense for which there may not be direct evidence. Circumstantially, you have to see whether these people could have been there into it. So that explain କରିବନି।
There is no evidence against the accused.
This is not 232.
Sahadev Pradhan.
Evidence ନାହିଁ ବୋଲି କରିପାରି that that's a different matter. But question is that when you are mentioning that I have accused, so what is that accused examination?
Examination has to be there.
ହାଜିରା ଫାଜିରା ଅଛି
C3 ଟା ଦିଅ।
ଏଟା ଫାଇଲ ଏଟା ରହୁଛି
ହାଜିରା ଅର୍ଡର ସିଟ୍ ଏଗୁଡା ମେନ୍ ଟା। ସେଇଟା ଦେଖ ପଛପଟ ଲାଷ୍ଟ। ନାଇଁ ଅଛି କି ସେଠି ଷ୍ଟେଟମେଣ୍ଟ ଅଛି କି ଏଇଥିରେ ଅଛି ଏଇଥିରେ ଲାଷ୍ଟ ସେଇଟା ଏଇଗୁଡା ଏଟା କାହାର ଏଟା ଅର୍ଡର ସିଟ୍ ଏଇଥିରେ ଲାଷ୍ଟ ଅର୍ଡର ସିଟ୍ ନା ସେଇଟା ଦରକାର ନାହିଁ। ଏକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ କୋଉଠି ଅଛି ଅର୍ଡର ସିଟ୍ ରେ ଏଥିରେ ଥିବା କଥା ତାହେଲେ ଦିସ୍ ଇଜ ଦି ୱାନ୍। ଅଛି ହଁ
17/7/1 17/7/1 accused statement
ସେଟା କଣ ଦେଇ ବହୁତ ସାରା ବିଷୟ
ଏଇଟା ଏଇ ଫାଇଲ ସି ଫାଇଲ।
other accused person, convicted accused person.
ରେକର୍ଡ ହେଇନି
ଲେଖିଦେଇ ଯୋଉଟା
ଲେଖା ହେଇଯାଇଛି।
17/7 convicted accused person ଯାହା statement
ନାଇଁ ସେ ତାଙ୍କର ଏଇ ଅର୍ଡର ପାସ୍ ହେଲା ପରେ ସେମାନଙ୍କର ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି ପରେ that is on
17/7
ହଁ 17/7
10/7 କୁ ଥିଲା 17
ହଁ 17 କିନ୍ତୁ ଇଏ ଗୋଟେ ଯଦିଓ ଲେଖିଛନ୍ତି
ନା
that the accused persons were examined. In fact, there is no such examination. So, ଏଇ ଯୋଉ 4 ଜଣ ଆପଣ 4 ଜଣ ଯାକଙ୍କର ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ର ଲାଷ୍ଟ କ୍ୱେଶ୍ଚିନ୍ ଟାକୁ ଆସନ୍ତୁ। ପ୍ରଥମ ଆକ୍ୟୁଜ ରହୁଛି ଆପଣଙ୍କର ପାଣୁ ସ୍ୱାଇଁ କିଏ?
ପାଣୁ ସ୍ୱାଇଁ ଫାଦର ଇନ୍ ଲ।
Yes. Father in law ର last question ହଉଛି 18 number question. Do you want to say anything more? ସେ କହିଲା ପ୍ରତିମା ମୋ ପୁଅଙ୍କ 1912 ବାହା ହେଇଥିଲା ପେଟ କାଟି ପ୍ରତିମା ମଲା ବାସ୍ ସେତିକି ଆଉ କିଛି ନାହିଁ। ତାପରେ then comes ସରୋଜିନୀ ଯୋଉ ଦଶହରା ଦିନ ପ୍ରତିମା ଉପବାସ କରିଥିଲା ରାତିରେ ପିଠାପଣା ଖାଇଲା ଚହ୍ଲା ପିଇଲା ତାପରେ ପେଟ ମୋଡୁଛି କହିଲା ଆମେ ତାକୁ ଲେମ୍ବୁ ପାଣି ଦେଲୁ ଭଲ ହେଲା ନାହିଁ ସୁଳ ମାରୁଛି ବୋଲି କହିଲା ବେକ ଉଠାଇ ମରିଗଲା ଦିନ 9ଟା 10ଟା ବେଳକୁ ପୋଡିବାକୁ ନେଲେ। ନେକ୍ସଟ କମ୍ସ ହଜବ୍ୟାଣ୍ଡ ନା ରଙ୍ଗପନି
ସେମ୍
ତାର ସେମ୍ ଗୁଣ ପାଇଁ 10 ମିନିଟ୍ ପରେ ଅଂଶ ନଖୁଛି ତାପରେ ସେ ଶୋଇଲା ଆମେ ଶୋଇଲୁ ସକାଳ ପ୍ରାୟ 4ଟା ବେଳେ 1 ଘଣ୍ଟା ବେଳେ
ଆଉ ରାତିରୁ ହେଲା 4ଟା 15 ସେ ମରିଗଲା।
ପ୍ରାୟ 4ଟା ବେଳେ ଦେଖିଲୁ ପ୍ରତିମା ମରିଯାଇଛି। 1 ଘଣ୍ଟା କିମ୍ବା 1.5 ଘଣ୍ଟା ପରେ ପ୍ରତିମା ନେଇ ପୋଡ଼ିଦେଲା।
ଆମର ତ
ତାପରେ ହେଲା
ସେ ବି ସେଇଆ
ବିଜୟ ସ୍ୱାଇଁ
ସେ ଆଉ ଟିକେ ଏକ୍ସପ୍ଲେନ କରୁଛି ଖବର ଦେଲୁ ବୋଲି।
ଇଏ କହୁଛି ମୁଁ ସେ ରାଉରକେଲାରେ ଥିଲେ,
ସେମାନେ କହିଲେ ପୋଡ଼ି
ଫୋନରେ ପୋଡ଼ି ଦିଅ କହିବାରୁ ଫୋନରେ ପୋଡ଼ି ଦିଅ କହିବାରୁ
ମୁଁ ଜିରଳି ଯାଇ ମଲ୍ଲା ରାଉତଙ୍କ ଭାଇଙ୍କୁ କହି ଦିନ 10ଟା ବେଳେ ଘରକୁ ଆସିଲି।
ମୁଁ କହିଲା ପରା ମୁଁ 12 ତାରିଖ ସୁଆଣ୍ଡସରେ ମଲ୍ଲା
ରାଉତ ପାଖକୁ ଫୋନ କଲି। ସେ ରାଉରକେଲାରେ ଥିଲେ, ସେ ଫୋନରେ ପୋଡ଼ି ଦିଅ କହିବାରୁ ମୁଁ ବିଜୁଳି ଯାଇ ବିରୁଳି ଯାଇ ମଲ୍ଲ ରାଉତଙ୍କ ଭାଇଙ୍କୁ କହି ଦିନ 10ଟା ବେଳେ ଘରକୁ ଆସିଲେ। ଏସବୁ କୁଆଡୁ ଆସିଲା?
ମଲ୍ଲ ରାଉତ ଇଜ ଏକ୍ସାମିନ୍ 12 ତ ମଲ୍ଲ ରାଉତ କୁ ବି ଆପଣ କିଛି ବାହାର କରୁନାହାନ୍ତି ଏଇ ଯୋଉ ଖବର ଦବା କଥା। You cannot say now that since the prosecution has failed to establish that it is a homicidal death, so no conviction under 302 is sustainable. Because you are the creator of all these things. By destroying it, the dead body, by cremating the dead body without intimating, the cause of death could not be ascertained. You are taking two pleas. One is of natural death, the other before them suicidal death. Then if both the things are ruled out in view of lack of cogent evidence, then the inference comes to the third one, that she died homicidal death. आपण natural death ର plea ଟା ନେଲେ ପେଟ ଇଏ ସେଗୁଡାକ
ବ୍ଲଡ ପେଚ୍ କଣ ଅଛି ବୋଲି ବ୍ଲଡ ପେଚ୍ କଣ ରୁମ୍ ରେ ଅଛି ବୋଲି ବାହାରିଛି।
ସେଇଟା କେମିକାଲ ରିପୋର୍ଟ
ନାଇଁ ଆସିନି କେମିକାଲ।
Let it see the page 109
ବାକି ଯୋଉ ସୁଇସାଇଡ କଥାଟା କହିଲେ ବାପା ଆଗରେ ସେଇଟା ମଧ୍ୟ whatever she has stated that is also not and then the trial court has discussed about this that how she came to the convictive under 302 say aspect re. Have you found out any decision, Mr. Pradhan, that you get ready? Because when the accused persons have disposed of the dead body, right? So the prosecution, obviously, there is no post-mortem report. In such a situation, if the how can the court will come to a finding that it is a case of homicidal death to convict him under 302? That also you find out. So search for the decisions.
Yes.
Allah. There are decisions also. Suppose the corpus delicti not found, dispose of kardele ba अन्य कोनोसी ये ताको कोनोसी stream को फोपा dead body मिलिलान. But otherwise it has been established that the accused persons are responsible for the death.
Everybody has seen suppose injuries ହେଇଥିଲା ଦେଖିଥିଲେ So some
uh,
formidable evidence is
ଏଠି ଏଠି let us say injuries ଦେଖିବାର କାରଣ ଅନ୍ୟ ବାହାରେ ଘଟଣା ହେଇଛି ତେଣୁ ଚାରି କାନ୍ଥ ଭିତରେ ଯାହା ହେଇଛି ତେଣୁ ସେଇମାନଙ୍କର ସ୍ପେଶାଲାଇଜ ଅଛି ତେଣୁ ଏମିତିଆ କେସ୍ ଗୁଡାକ ଦେଖନ୍ତୁ ଯୋଉଠି କି ଘର ଭିତରେ ଘଟଣା ହେଇଥିବ dead body dispute. We want that you should study on these lines also. ହେଲା? And you also see that ହେଲା? ବାହାର ଘଟଣା ନୁହେଁ ମାନେ ଯୋଉଠି ଆଇ ୱିଟନେସ୍ ଇନେ ଘର ଭିତରେ ଡାଉରି ଡେଥ୍ ହେଇଥିବ ଡେଡ୍ ବଡି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଥିବ ସେଠି ମାନେ କୋର୍ଟର ଡିସ୍କସନ୍ସ କଣ ରହୁଛି 106 ଅଫ୍ ଦି ଏଭିଡେନ୍ସ ଆକ୍ଟ ଉପରେ ହେଲା? ମଲ୍ଲ ରାଉତର ତାର 161 ଟା ଟିକେ ବାହାର କଲୁ DW12 ର
statement thoroughly.
161 then ମଲ୍ଲ ରାଉତ ସଂଶୟ ଘରକୁ ଗଲା ଦୋକାନ ଖାଇବାକୁ ପିନ୍ଧିବାକୁ ଦେବାର ଅବହେଳା କରୁଥିଲେ ଯୌତୁକ ନ ଆଣିଲେ ଆସିବୁ ନାହିଁ ଆଚ୍ଛା ଏପରି ଝିଅକୁ ମୁଁ କହୁଥିଲି ମୁଁ ଏସବୁ ଶୁଣି ତାଙ୍କୁ ଟଙ୍କା ଯୋଗାଡ଼ କରୁଥିଲି 28 ଆମ ତାଲାକ ଅଛି ଝଗଡ଼ା ପରେ ମୁଁ ବୁଝାସୁଝା ଷୋହଳ ତାରିଖରେ ଆଦିକନ୍ତ ନାୟକ ଠାରୁ ଟେଲିଫୋନରେ ଖବର ପାଇଲି ମୋ ଝିଅ ପ୍ରଥମେ ତାର ଶ୍ୱଶୁର ଘର ଲୋକ ବଳକା ଯୌତୁକ ଟଙ୍କା ପାଇଁ ମାରିଦେଇ କୂଅରେ ପକାଇ ତା ସୁଆଂଶୁ ରାତିରେ ଝିଅରୁ ପୁଅକୁ ବାହାର କରି ରାତି ନପଣ ତରବରେ ପୋଡ଼ି ପକାଇଲେ ଆମ ଗାଁରେ ଥିବା ମୋର ବଡ଼ ଯା ମୋର ଶ୍ୱଶୁର ଘରକୁ କୌଣସି ଖବର ଦେଇନାହାନ୍ତି ମୁଁ ଗାଁକୁ ଆସି ଗାଁରେ ଲୋକମାନଙ୍କୁ ଶୁଣି ଖାଣ୍ଡିରେ ରିପୋର୍ଟ ଦେଲି ମୋର ଝିଅ ତାର ଶ୍ୱଶୁର ଘର ଲୋକମାନେ ଯୌତୁକ ଦାବି କରି ନାନା ହଇରାଣ ତାକୁ ମାରି So, Mr. Pradhan, you see those decisions, huh?
Madam.
ଏଇ ଟାଇପ୍ ର କେସ୍ ହେଇଥିବ ଘର ଭିତରେ ଡେଡ୍ ବଡି ଡିସ୍ପୋଜ ଅଫ୍ କରିଥିବେ ଇନଲସ୍ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସଙ୍କର ଆଉ ପୋଷ୍ଟମର୍ଟମ ହେଇନଥିବ ସେଠି 106 କୁ ଡିସ୍କସନ ହେଇଥିବ କଣ ତାଙ୍କର ବର୍ଡନ ଅଫ୍ ପ୍ରୁଫ୍ କେମିତି ଡିସଚାର୍ଜ କରିବେ ତେଣୁ ଏଇ ଟାଇପ୍ ର ଅଲଗା ଟାଇପ୍ ର ପ୍ରି ନିଅନ୍ତି ମଧ୍ୟ ଏମିତି ହଠାତ୍ ମରିଗଲା ଇଏ କଲା କାହାକୁ ନ ଜଣେଇକିନି dead body position. So many cases are there. You also
Yes.
examine, huh?
And you also verify the 14 of the judgment where the court is saying that the following facts are proved against the accused persons. Deceased Pratima married accused Rankar. The other accused persons are in-laws of the deceased. Her death occurred otherwise than under normal circumstances. Soon before her death, she was subjected to cruelty. So where is 302? In order to come to a conclusion for 302, a homicidal nature of death is there. Where has it discussed? See, it is 304B is all right. 302 ready thibe. Hala?
Third जो जिनसटा कौन otherwise and then normal circumstances ସେଇଟା ପାଇଁ ତାକୁ କାଟି ଯିବ କାରଣ suppose let us say ये माने normal circumstance କହୁଛନ୍ତି normal circumstance ରେ ଯାହା ହବା କଥା ସେଇଟା ନାହିଁ ଏଠି ତେଣୁ it is otherwise than normal circumstance ଆସିଯିବ ଆଉ ମାନେ demand ଇଏ ରହୁଛି ବାପା ମାଙ୍କର
soon before death
soon before death ହଉ ସେ 304B material ଆସିବ but what about 302 homicidal death କଣ automatic ଗୋଟେ presume କରାଯିବ suppose ତାକୁ ଅନ୍ୟ କୌଣସି suicide ହେଇଥାଇପାରେ ବା ଅନ୍ୟ କୌଣସି ଇଏ ହେଇପାରେ ତେଣୁ all these unnatural death will come within that 304B and but 302 it requires
suppose the death would have been with some so as a matter of abandoned precaution 302 is also charged in alternative.
That is
correct. So alternatively if the death would not have been otherwise than under normal circumstances relating to the cause of dowry, then 302 would have come because injuries were there. Here the dead body has been cremated. So what is the circumstance on which we can bring it to 302? Okay. You can
demand of torture that এটা রহিলে ମଧ୍ୟ otherwise than normal circumstance death এই তিনটা মনে করব ଆମେ ধর evidence ରୁ ଆସିଲା but why it would be in that circumstances only 302 why not 304B କାରଣ ସିଏ ଆସିଗଲା ମାନେ option ରହିଯିବ ନା it may be sentence can be imposed on 10 years it can be also life imprisonment but 7 years above ଦିଆହେଇଯିବ ସେଠି ଆପଣଙ୍କୁ ଏଠି you also see those difference ଏଟାକୁ ଲେଖିଦିଅନ୍ତୁ ନା hard in part କରି ଏଟାକୁ କେବେ ରଖିବା ଆମେ ମଙ୍ଗଳବାର ଦଉଛୁ କାରଣ ଗୁରୁବାର ଅନ୍ୟ matter ରହୁଛି next week
18 ମାଇଲ
question of 11th get ready both of you are getting now 5 days time
yes
to get ready